Inclusion for motion.
Yes. Motion, listed motion.
কি বুঝতে পারছি না আমি। The slip motion.
Motion.
Mentioning for motions, you just hand over the slip.
For notice, my lord.
9th April থেকে pending আছে already mentioned on 9th April. File is lying with court number.
Only motion matters. Just hand over the slip. We shall consider. Yes.
But this is a matter which is due to appear today, my lord. The interim order we have till tomorrow. My lord will kindly recollect it is a writ petition challenging CBI proceeding where Section 6, my lord, of the Delhi Special Police Establishment Act is pending before the Honorable Supreme Court. Your lordship's desire was to know whether the similar matter is this is the identical matter, my lord. Your lordship sought CBI to come with the direction, I mean instruction whether this is the identical matter. My lord, this was mentioned
482 matter.
for it. My lord, it's a 226 writ filed.
Achha.
Now, all other matters are extended till disposal. We were also asking for the similar, requesting for the similar relief, my lord. It was supposed to appear today, somehow not in the list, my lord. I'm protected till tomorrow. Tomorrow, your lordship has already kept that CBI matter. That is also for interim order, my lord. No final hearing this side, my lord. We will not trouble your lordship. If this may also appear, my
কালকে
lord.
ওই একটা সিআরআর আছে না, ওইটা নিয়ে নিয়ে ওটার সাথে পাশে সামনের সঙ্গে রেখে দিন। Arising out of the self-same PS case or self-same CBI
No,
case.
no, no. But since you, but it's for interim order again, for extension. In that matter, there is no interim order will be requested.
The other matter,
But there we will be requesting for interim order only. No lengthy hearing, my lord.
এটা হচ্ছে for extension of interim order করো।
Most obliged. Because that your lordship has,
উপরের দিকে রাখবে।
I think your lordship has given the direction so that the matter appears as 2 o'clock. There is a 2 o'clock fixed matter tomorrow, perhaps.
Very good.
That matter will be second one, I'm told. And then this
for
will appear
extension of
as
matter 2 PM রেখে দাও। Yes, sir.
most of it. Same, my lord, same.
Oh, same.
Mentioning a matter, lordship, it is running in the item bottom of the list. It is a land of Kazi Nazrul Islam. Already report been filed, matter is ready, only a direction is required. So any day if lordship fix, because there is a order, the matter to be appeared on 2nd April, but the matter is running at the bottom of the list and the matter is ready and third party is encroaching the property, but my client unable to take any steps because erroneously Bangladeshi.
It is in my list.
Yes, lordship.
It will be taken up.
Lordship, any day be fixed at the bottom of the
No, I
list.
cannot update the matter.
Lordship, any day, lordship.
No, no. Sorry.
If lordship.
Don't embarrass this court. এইগুলো কোথা থেকে এসে গেছে?
It is in
কালকে
adjourn motion, but it is under the head adjourn motion, but it to be in motion. It comes by mistake or not, I don't know. It is under the
It
head.
is in today's list.
Yes,
Item number
45.
45.
45. Erroneously comes under the head adjourn motion, but it need to be listed under the head motion.
ওটা ওর সাথে রাখো, কারণ রাখো।
If the matter be shifted under the head motion, then also there will be chance at any day. 45.
আমরা কি অ্যাডজন মোশন গুলো তুলে আনতে পারছি না? অ্যাডজন লিস্টেড মোশনে দিয়ে দাও।
One day we fixed for that.
Listed motion. না এটা রাখুন, ভুলে যাবেন এটা।
তাহলে একটা কাজ করুন, ওটা নিয়ে নিন, ওটা ফরওয়ার্ডসে আনুন, আমি তারপরে দেখে একটা অর্ডার ডেট ফিক্স করে দেবো। নেক্সট উইকে একটা মানে এপ্রিলে তো আজ I'm fixing it on 1st May for orders. Thereafter, I shall fix it. Pleadings are complete.
Everything complete, report filed by government and only a direction.
All
is
right,
required.
I shall see. Call the list, call the list.
Number one. For exceptional entry order, if you have to kindly see the order, 22nd January 2025. I will hand you over my code. You have to find out from the. Can you see the first order? It's the first order. Can you peruse that? You also will find what is the matter about.
ইমপ্লিমেন্টটা কোথায় ছিল এখন কোথায় পাবো?
The pleadings are complete.
So report was called for, we have filed a report and we have received a copy of the exception as well. As far as ADDA is concerned, we have filed a report.
Who are the answering respondents?
Not ADDA is the only answering respondent, but the state has also been made a party.
It has to be made.
And the policy decision, my lord, we are guided by the decision of the state. So state is a necessary party here.
What is your report?
The report was filed on the last day.
We have prepared exception. Unfortunately, stacked this however, I am. And you also. In what in proper manner. Last order is 14 February 2025. This is our exception. Can we fix a date for hearing?
It cannot be taken up today.
Up to my lord. 30th is the date when it has come for orders. 30th interim order is there.
একটা রিপোর্টের কপি
Let me see what is the matter.
That order, I placed with the order before my lord. Everything has been put there.
থাকে দিন এই মুহূর্তে নেই পরে দিন
Well, desire to hear it today.
Let us take up.
I have to bring one citation. I have to show to you. One, only one.
You're not ready.
Only that citation is not with me. Otherwise, I am ready. There is an earlier order. If you have to produce that, you have to find what is the matter.
That I've seen.
The Subra Ghosh. Subra Ghosh.
Wherever I'll get the its interim order,
Interim order. Interim order is. I handed over to you. See the copy.
14th February.
Just now handed over to you.
Ashu.
Up to 30th April.
By an order date 14 to 2025. এটা ফেরত দিয়ে দাও কি লোক
Bibliography. 23 gross direction part 5 has sub notice up to the minor advocate representing the alleged contemner, indicating that the matter will be taken up.
Which for the alleged contempt.
We come to page.
Give me a second, sir. It is a Bornagar municipality.
My lord. So the order passed by your lordship is at page 25 and the direction is
Page 25 of?
the contempt application.
Page 25 of the contempt application.
This is the order passed by your lordship on 1st October 2020.
What is the operating part?
Page 26, paragraph 6. That is the direction on careful consideration of the entire materials as placed before this court. It thus reveals that the private respondents practically admitted at least some deviation in the construction at the aforementioned premises. This court considers that justice would be served if the respondent number 1 to 5 are directed to come to a finding as to whether the construction which has been made by the private respondent at premises number so and so under PS Boranagar is at all minor in nature or not. In the event it is found that such deviation is not in accordance with the aforementioned notification dated such and such, the Board of Councillors of Boranagar Municipality shall proceed with the provisions of section 218 of the West Bengal Municipal Act against the private respondent. That was the direction passed by your lordship. Apart from that,
218 is a demolition proceeding.
your lordship, the hearing was given pursuant because the direction was that prior to taking decision, the Board of Councillors shall give hearing to all the parties. In terms of the order passed by your lordship, by order letter dated.
Who is the respondent number 2 there?
Lordship, respondent number
Chairperson.
Yes, chairperson. Now, lordship,
So what is the reason order?
lordship, kindly come to page 33. That is the reason order of a one line. Page 33 from the start, the appearance has been recorded till the last paragraph. Your lordship will find so and so Sri Amitabh Mandal up to that paragraph, only the appearance has been recorded. Thereafter, the reason order. After threadbare discussion of the Board of Councillors, decided that the rear side exit gate will be closed and boundary wall will be constructed in that place.
Hey,
Thus, the order of Honorable Court is complied with. That is
so
the
what
reason
is this
order.
order?
My lord, I'll satisfy your lordship. But there are two parts of your lordship's directions, my lord. The first part was that this court considers
Para.
page 26,
Yes.
internal page 2 of your lordship's order.
Huh.
Page 6, paragraph 6, my lord. There are two parts of lordship's directions. This court considers that justice would be subserved if the respondent number 1 to 5 are directed to come to a finding as to whether the construction which has been made by the private respondents at premise number so and so is at all minor in nature or not. This is one part. Now, my lord, kindly
So
take
they have to come to a finding.
yes, come to a finding. Now, my lord, yes. Now, my lord, page 33, which has been placed before your lordship.
Just a minute. The respondent numbers want a director to come to as to whether construction of such and such is at all minor in nature or not.
Or not. But, that is the
If it
first
is-
part.
So what is that finding?
Yes, that finding, your lordship has said, my lordship kindly takes up the order
Yes.
passed by the municipality at page 33.
Yes, sir.
After threadbare discussion of the municipality decided that the rear side exit gate will be closed and boundary wall will be constructed. My lord, this portion, it has not been
No,
recorded.
sir. There was a direction from this court to come to a finding whether that is that those deviations are
Minor or in nature or not. Yes.
What is that finding?
My lord, that finding, no, lordship has kindly see what is the direction passed by the municipality. The ultimate finding, the threadbare discussion, the councillors decided that the rear side exit gate will be closed and the boundary wall will be constructed.
Sir,
But
municipality will direct the court or court
No,
will
no,
direct the municipality.
no. Your lordship's order is to be complied with.
Huh?
How this has been complied is at page 33.
No, what is the finding?
That finding is it has not been recorded in as many words. That
Then-
I get. So, my lord, in that
event,
event, no, in that event, let this order be kept in abeyance. We can give them a fresh hearing because they have to come to a particular finding. This finding they
This
are.
is a contempt.
This is a contempt to my lord, but
I am to see whether the order of the court is complied with or not.
My lord, what will in that event, but this side exit gate will be closed and bound.
Sir, you have two options.
My lord,
Either you have to comply with in letter and spirit,
yes,
or you have to prefer an appeal and get
No,
the order quashed.
that is what I am submitting before your lordship. In that event, if your lordship is not satisfied with this order, and since this has not been recorded, whether this is minor or not, this recorded has to be there. Then, my lord, we can keep this.
First, you have to come to a finding it is minor or not.
Yes, that is what I am
If it is
submitting.
minor, you pass appropriate order.
And if it is
if
not,
you-
then 218.
Then you will.
Yes,
What is that? Nothing
that
has been
finding
done.
has to be there. That is why I said to them that they said that yes, that finding is not there. That is why I was beseeching your lordship. We'll keep this order is events. We'll give them another hearing and we'll consider your lordship's order and come to a.
So I shall
particular
start a de novo hearing.
No, not in the content proceeding. We'll do. Not your lordship, but we'll do.
You issued an order for keeping this order in abeyance.
Yes, we'll do that. Your lordship just give us some time.
I will record your submission.
Yes, your lordship records my
That
time.
you give
We'll
an
do everything. Yes,
undertaking that by such and such day we will keep the issued an order, keeping this order up in abeyance, and we will act in accordance with the order.
Yes, we'll give them another hearing and then come to a particular finding in directions passed by your lordship's order. And lordship kindly
The
adjust this for
receipted
some time.
notice, the receipted copy of the notice dated 25
I have already talked with them. I said that you have to come to a particular finding. That is why I made my submission this way, my lord. Grateful to your lordship.
Don't defend them for an unnecessary.
No, never, my lord.
Ask them to comply and give them proper guidance.
Right. Grateful to your lordship. Obliged, my lord.
Number 3.
My lord, I'm for the petitioner. Lordship, this matter has already been heard and decided by one of the show.
Mr. Saha,
There is some correction.
you usually appear on behalf of the Board of Municipal
In all the matters.
in all the matters.
Petition also he appeared.
Well, I also appeared in the writ petition.
Oh, acha, acha. No. You are the standing counsel or something like
Yes,
that with of the Board of Municipal.
Very
তাহলে তো ওই অনেক সময় appear
না,
না করলে
না, আমি
বলবে।
এটা ভার্চুয়ালি অ্যাপিয়ার করেছিলাম, নামটা রেকর্ড হয়নি। কিন্তু আমার
হ্যাঁ, জানি তুমি virtually appear করেছো, yes.
আমি বলেছিলাম
হুম,
ভার্চুয়াল ছিলাম বলে নামটা হয়নি।
Yes, call the next matter.
Grateful.
This is a matter pertaining to Port Blair. Yesterday, I have sought.
Yes.
There is some minor slipshod, Lordship, that needs to be rectified. But there
এটা
is
কি
some
আমাদের এখানে চলে
urgency
এসেছে?
also,
এটা
Lordship.
আমাদের এখানে হবে না, তাহলে একটা কাজ করো, আন্দামান ম্যাটার আমাদের একটা সাপ্লিমেন্টারি লিস্ট বার করে করতে হবে। তুমি যেটা বললে, come tomorrow.
Lord, tomorrow being the last day, Lord Tahsildar, at any moment, Lord, would see the eviction order. It's staring in my face. So only yesterday I sought leave. Lord, if it is, I have no problem, Lordship. The problem is the color of the eviction order is such a way my building would be demolished. Lord.
Taken up tomorrow at 10:30.
My lord,
I'm grateful, Lordship.
my lord, there must be
Lord,
some
can-
mismatch in
can
the
it
cost
be a-
letter. My lord, my number and name has appeared in the cost list, my lord.
কি বলছো? তাহলে এটা কি হবে? Please come back.
My lord, I'm grateful. I'm grateful.
It is because of the mistake of my ACO, it is
My lord,
unnecessary.
oblige me.
যা ব্যবস্থা করা করুন, আমি সাপ্লিমেন্টারি লিস্ট একটা বার করুন। আইটেম নাম্বার 3 টা তাহলে হলো না এখন। কল আইটেম নাম্বার 4 দেন।
I don't know, I'm paying 1 day accommodation. On the last question, lawsuit director to take instruction. I have a talk with the land manager, my lord, the Salt Lake property. Only, my lord, 1 day. Can you
Not
take it
today.
over?
4 not today. Next.
In the top, my lord.
It will retain its position. এই আইটেম নাম্বার 4 যেন একই জায়গায় থাকে।
petitioner. I'm for the respondent number
ওটা যেন
13, my
একই
lord.
জায়গায় থাকে।
Yes. 5, I'm for the petitioner. This is the case, my lord, inaction and non-action on part of the, my lord, the respondent's authority.
Which respondent number 13?
I'm responding. Yes,
I'm led by Mr. Sabir Ahmed, my
Where
lord.
is the affidavit service?
Yes.
You are led by?
Mr. Sabir Ahmed, my lord.
But this is, my lord, non-consideration and, my lord,
Give
the
me a second, sir.
inaction on the part of the respondent.
What are the answering respondents?
Well, the answering respondents is, my lord, the
I am for the statement.
state. State is, my lord, the assistant respondent number 7 will consider my representation because this is the case of, my lord, the State Highways Act, non-consideration of my representation.
Where is your representation?
My lord, representation page 37. Start from page 37, 38 is my penultimate portion.
Yes.
এটা দাও একটা দাও এটা may I hand over?
I have also.
Justice.
আচ্ছা তো বই আছে বই।
Content.
That will be considered by the respondent number 7, madam.
Yes, yes.
Section.
After taking a report from the BLR.
Yes,
Yes,
madam.
And upon hearing all
They
the
will-
parties,
all the parties, my lord, they will give the
and spot inspection also, madam.
spot inspection, the hobby, now, like encroach approved.
Respondent number,
7.
who is the assistant engineer?
Yes,
Respondent
madam.
number 7.
Respondent number
Respondent number 7.
Ashu. And the
I am for the petition.
I am the state.
Why the lawyers from bail bench are coming before this court, huh? This is very unusual. Mr. Ahmed is here, you are also here.
I believe we have been stigmatized.
No.
On the last occasion.
Because you are a known face in those benches, which is why I am asking.
And we are missing your lordship like anything.
No.
We hope your lordship will be on that side very soon.
Sir, everything is not in my hand. Yes, sir.
On the last occasion, my lord had directed me to serve upon the respondent number 2.
Yeah, the item number 5, no?
6.
Oh, item number 6. Dinesh Kumar. Well, yes, sorry.
But I am the state, my lord.
Yes, sir. Give me a second.
My lord.
Forthwith, cancel and resign or withdraw the order number. Your mutation application has been not considered favorably.
My lord, I have.
No, no. What is that?
This is a report, my lord.
Yes.
Which I have received
Give me
yesterday, my lord.
Give me the report.
Lord, may I place?
Sir, what is the yes? Place your yes.
Now, the subject matter of the challenge is at page number 52.
52? 52.
52, my lord.
Give me a
Annexure
second.
P4.
Give me a second, sir.
My lord.
Not willing to give any transfer fee, my lord. In this case, my lord.
Yes. Sir, it is a little bit illegible. Will you please kindly place, sir?
50, yes, my lord. Now, this is a letter dated 23rd April 2024.
Miss Geetika Goyal, who is she?
Page 52, my lord. My lord, she is the minor daughter of the petitioners.
Oh, I see. Yes, sir.
Now, this is a letter dated 23rd April 2024, written by the respondent number 2 to the minor daughter of the petitioners, wherein by subject they have asked for deposit of permission fee for mutation of 100% share by way of will probate concerning plot number so and so, Salt Lake so and so, in terms
I'm
of
directed to request you to deposit an amount of such and such only through government receipt portal system.
Towards permission fee?
Permission fees for the purpose of
as mentioned above in respect of the aforesaid plot of land within 30 days from the date of receipt of this letter, and to submit the original receipted e-challan in duplicate to this
deposit of permission fees for mutation
My lord.
of 100% share by way of will probate.
Well, actual, my lord, the land was.
Sir, wait. I will hear you. It is his case.
Now, my lord will kindly take a page number 53, my lord. This is a notification which they are relying upon. My lord will kindly mark the date.
No, this letter is under challenge.
This letter is under challenge, my lord. Their action in seeking a sum of rupees 20,40,650 as permission fee. My lord will kindly take note, permission fee for causing mutation, my lord. They have already taken the mutation fee, my lord.
Achha. Yes, then what
kindly see page number 53. This is the notification, my lord, which they are relying upon.
Page number
53.
Yes.
This is the notification dated 22nd June 2012.
Yes.
Now, my lord, I will be placing paragraph number 4. So this is a notification on which they are relying upon for seeking the permission fee. In the like manner, and also in order to put an end to such unauthorized transfer as well as to increase revenue to the government exchequer, the government has been pleased to order that the government of West Bengal may allow the lessee of a residential plot of building thereon of Bidhannagar to transfer his leasehold right to others for unexpired period of lease term, inter alia by imposing transfer fees at the rate of rupees 5 lakhs per katas for the time being and on such terms and conditions as may be fixed from time to time, to seek the permission of the government to transfer his leasehold right to others. The lessee / mutated lessee shall have to apply to the Principal Secretary to the Government of West Bengal, UD Department, Nagarayon, so and so, stating his intention for such transfer. The transfer fees, however, will not be applicable to the case that are within the blood relations, father, mother, husband, wife, brother, sister, son, daughter, son's daughter, daughter's daughter, and in those cases, only a nominal amount of fees may be fixed by the government from time to time. Now, next notification they have issued, that is at page number 55, my lord. Annexure P6. My lord, they have added a proviso, my lord.
Give me a second. এই করলেন আমাকে একটু দিয়ে দাও না স্লিপ করলেন এটা দাও না page 56 is a copy of the later date 9th May.
Page 55, my lord, page 55.
Oh, I see.
Page 55 is a notification. I am showing this notification to the my lord, because my lord, all these notifications have been quashed by this honorable court in the earlier proceeding.
Kindly please, sir.
The judgment of this honorable court.
No, notification.
Now, this is a notification dated 2nd September 2013. My lord will mark the date. In partial modification of notification number 2709 SLAL 4S9 2004 dated 22nd June 2012, the following explanation is hereby incorporated and will be deemed to have been incorporated from the date of issue of the notification referred to herein before. After paragraph 4 of the above mentioned notification, the explanation is as follows. Explanation. It is, however, made clear that all the devolution except in favor of close blood relation, that is father, mother, husband, wife, brother, sister, son, daughter, son's children, daughter's children, grandfather, grandmother, shall be deemed to be transferred and transfer fees will be applicable. Now, my lord, coming to the factual aspect of the case. But originally a lease of deed dated 16th October 1980.
Just a minute. So far, these two notifications, that is 22nd June 2012,
my lord,
and 2nd September of 2013,
my lord,
are concerned.
Are already quashed by this honorable court. Despite
that, I am asking.
My lord, that has already been quashed.
Where from will get that?
My lord, may I hand over a copy of the judgment, my lord, passed in a writ petition by His Lordship Honorable Justice Pratik Prakash Banerjee, as His Lordship then was. My lord, may I hand over, my lord, I am relying on paragraph number 16 at page number 8. Paragraph 16 at page number 8, my lord. There are several judgments, my lord. My lord, I'll be placing, my lord. I'll hand over a copy. Paragraph 16, page.
Yes.
My lord, may I place, my lord?
Yes, sir.
I therefore do not find that the state of West Bengal has any right under the deed of lease by which it is granted the lease to the original lessee to restrict the right of bequest by a will of a leasehold to the extent of unexpired period of lease to any person, whether by regulating the right on the basis of payment of permission fees or otherwise, whether to a stranger or to anyone who is not covered by expression closely blood relation, whether under the notification dated June 22, 2012, which we have just placed, my lord, as in paragraph number 5, or September 2, 2013, as in paragraph number 6 of this judgment, in terms of the covenants of the lease deed dated July 14, 1976. To the extent, therefore, the said notification cannot be given any effect and are quashed. Naturally, therefore, the demand for permission fee dated December 21, 2017, which is annexure P15 to the writ petition, is also quashed. As a consequential relief, I direct the respondent authorities to process the application dated August 29, 2016, as corrected on February 3, 2017, by mutation of the leasehold in terms of the writ petitioner and other legatees under the probated will dated August 4, 2009, according to their respective shares in accordance with law, without demanding transfer of permission or mutation fee, and to pass a reasoned order in this behalf within a period of 3 months from the date of communication of this order. If the application is allowed, then mutation certificate shall be issued within 3 working days from the date of this order. My lord, there is also another judgment passed by the coordinate bench of this honorable court on the similar issue, my lord. Now, thereafter, I will be taking, my lord, to the lease deed, wherein the lease deed executed in this also particular case also permit, my lord, bequest. My lord, may I hand over the copy of the judgment, my lord, passed by this honorable court, my lord, by His Lordship Honorable Justice Vishwajit Basu, my lord. My lord, may I please paragraph number 1 to 4, then I'll be taking, my lord, to paragraph number 8 and 12.
1, 2,
4, then paragraph number 8 and 12.
Yes.
The governor of the state of West Bengal executed a registered deed of lease in favor of one Maniklal Sen Gupta for a period of 999 years in respect of lot number so and so. The said Maniklal Gupta constructed a building on the plot of land and in terms of the building plan sanctioned by the Bidhanagar municipality. The said Maniklal Gupta on June 11, 1996, executed a will thereby bequeathed the said plot of land and the building standing thereon in favor of the petitioner. The petitioner, being the executor after the death of the said Maniklal Gupta, applied for grant of probate of the said will before the learned district delegate Barakpur district 24 Parganas North and obtained the same. The petitioner thereafter on May 15, 2006 applied before the respondent number 4 to get his name mutated in respect of the said plot of land for the unexpired period of lease upon payment of requisite fees. The respondent number 4 kept the said application of the petitioner for mutation pending for a considerable period of time. The petitioner, by a representation dated June 16, 2012, demanded immediate disposal of the said application for mutation, but the respondent number 4 did not pay any heed into the said demand of the petitioner. The petitioner, complaining inaction of the said respondent to dispose of the application of the petitioner for mutation, filed a writ petition being so and so. The learned single judge of this court, by the judgment and order dated June 28, 2012, disposed of the writ petition with the following order. Having regard the nature of the grievance raised in the writ petition, I find no reason to keep the writ petition pending. It stands disposed of with a direction upon respondent number 3 to consider and dispose of petitioner's representation dated 16 June 2012, being annexure P10 to the writ petition in accordance with law as far as possible, but not later than 2 months from the date of receipt of the copy of this order. Disposal of the petitioner's prayer shall be preceded by an opportunity of hearing. In the event the prayer of the petitioner is declined, a reasoned order shall be passed. On the contrary, if the prayer is allowed, necessary steps for mutation of his name shall be taken as early as possible. No opinion is expressed in the merits of the petitioner's claim, and all points are left open to be urged before the respondent number 2 and be decided by him. The respondent number 4, pursuant to said order dated June 28, 12, had disposed of the said representation of the petitioner by order number so and so dated October 31, 12, being annexure P1 to the writ petition. The respondent number 4, by the said order, had directed the petitioner to submit required documents at an early date for further proceeding of the matter and to deposit necessary government fees as per same notification has been relied. The legality and validity of the said order of respondent number 4 is challenged in this writ petition. Now, thereafter several judgments of the Supreme Court and this honorable court has been relied upon. Lord, I'm not placing that.
Paragraph 8.
Now, my lord, I'll take my lord straight to paragraph number 8. Paragraph 4 of the subject notification imposes transfer fees at the rate of rupees 5 lakhs per kattha to get the permission for transfer of leasehold right by the original lessee to others for the unexpired period of lease. The said paragraph of the subject notification is quoted below. For my lord, I've already placed this particular paragraph. I'm not placing it again. Now, my lord, paragraph number 12, my lord. Thereafter judgments have been referred, my lord, at page number 8. Paragraph 12, page number 8. In view of the discussion,
Paragraph number?
Paragraph 12. Number 12 at page 8, my lord. Paragraph 12 at page 8. In view of the discussions made above, the part of the order impugned passed by the respondent number 4, dated October 31, 2012, be annexure P1 to the writ petition, whereby the petitioner is directed to deposit the necessary government fees in terms of notification number so and so, is set aside, and the respondents are directed to mutate the name of the petitioner in respect of the subject plot and the structure thereon for unexpired period of lease upon compliance of the necessary formalities.
Very good.
Now, I'll further rely, my lord, on the judgment of the
not required. So these are these two judgments have not been.
No, my lord. I haven't come across.
It has only set aside in division bench of Supreme Court.
No, my lord. But even all these judgment, my lord, has the source from the judgment of the honorable Supreme Court. In the Lakhinder Kumar judgment, my lord, I also placing, my lord, that judgment. The state of West Bengal versus Kailash Chandra Kapoor.
In respect of Salt Lake property.
In respect of Salt Lake property, my lord. Well, kindly give me a moment. Yeah. Well, paragraph number 1 and paragraph number 7 I'll be relying upon. It's reported in 1997, paragraph volume 2, SCC 387. Or my place, Miller.
Give me a second. Paragraph number?
1, my lord, 1 and 2 for facts, my lord, and paragraph number 7 for law point.
Yes, sir.
Order leave granted, we have heard the learned counsel on both sides. This appeal by special leave arises from the judgment of the division bench of the Calcutta High Court made on January 19, 1996 in appeal number so and so. The admitted facts are that the lease for 999 years was granted by the government of West Bengal to one Tapan Kumar Malik on July 28, 1983 for assigning a plot of land number so and so and measuring so and so. The lessee had executed a will in favor of the first respondent, a stranger.
Your client is also a stranger.
My client is also a stranger. He has got the right in the property by virtue of a bequest made by a will. The will was duly probated, my lord. And my lord, thereafter we have presented an application for mutation.
I understand, sir. Thereafter what happened?
A stranger to the
So
family.
I understand, sir. Facts are almost same.
My lord. Paragraph
Then-
number 7, my lord. Last paragraph may I please, my lord.
7. Is there any paragraph number?
Page number 7, my lord. Page. I'm sorry, stand corrected, my lord. Page number 7, last
Page
paragraph.
number, sir.
Page number 7, last
Just
paragraph.
a minute, just a minute.
Last paragraph. Last paragraph.
Yes.
In view of the above settled legal position.
Huh.
In view of the above settled legal position, the question is whether the bequest made by the Malik in favor of respondent is valid in law and whether the governor is bound to recognize him. It is seen clause 7, 8, and 12 are independent and each deals with a separate situation. Clause 7 prohibits sublease of demised land or building erected thereon without prior consent in writing of the government. Similarly, clause 8 deals with transfer of the demised premises or building erected thereon. Thereunder, the restricted covenants have been incorporated by granting or refusing the permission with regard to preemption. Similarly, clause 12 deals with the case of lessee dying after executing a will. Thereunder, there is no such restrictive covenant contained for bequest in favor of a stranger. The word person has not been expressly specified whether it relates to the heirs of the lessee. On the other hand, it postulates that if the bequest is in favor of more than one person, then such persons to whom the leasehold right has been bequeathed or the heirs of the deceased lessee, as the case may be, shall hold the said property jointly without having any right to have a partition of the same, and one among them should alone be answerable to, and the government would recognize only one such person. In the light of language used therein, it is difficult to accept the contention of Sri V.R. Reddy that the word person should be construed with reference to the heirs or bequest should be considered to be a transfer. Therefore, connotes normally between two living persons during life will take effect after demise of the testator, and transfer in that perspective become incongruous. Though, as indicated earlier, the assignment may be prohibited and the government intended to be so, a bequest in favor of a stranger by way of a testamentary disposition does not appear to be intended in view of the permissive language used in clause 12 of the covenants. We find no express prohibition as at present under the term of the lease unless the government amends the rule or imposes appropriate restriction covenants prohibiting the bequest in favor of strangers, or by enacting law, there will be no statutory power to impose such restriction prohibiting such bequest. Now, a similar covenant has been there in my lease deed. I'll be
Very
showing.
good. Now, what?
My lord will kindly take up. Now, there are similar judgments of this
So
honor.
you have obtained the probate.
I have obtained the probate, my lord.
You have annexed that.
Yeah, I have annexed that, my lord.
Where is the probate?
My lord, the probate order is at page number 39.
Probate order is at page number 39.
By learned district judge at Barasat, my lord. My mutation is also done with the Bidhanagar Municipal Corporation.
So Bidhanagar Municipal Corporation has granted the mutation.
Mutation fees, my lord, subject to correction, my lord. Subject to.
Bidhanagar Municipality has mutated.
So kindly give me a moment, my lord. No, that is not there, my lord. I beseech your lordship to kindly take a page number 20, my lord.
Page number?
20, my lord, lease deed starts.
Yes.
My lord, by this particular lease deed, my lord, the concerned testator Ramya
Where is the
Kumar,
will?
my lord, will is at page number 40, my lord, 42, my lord.
Who is the beneficiary of the will?
My lord, the minor daughter of the petitioners, my lord.
Okay. And her mother is the executor.
Is the executor.
So what is their case? Yes, what is your case, sir?
My case, my lord, actually, my lord, the original lessee, my lord, Omyo Kumar Mukhopadhyay. After his death, my lord, his legal heir, Srimati Mohma Chattopadhyay, mutated her name in the said plot, in the sort of said plot, my lord. Thereafter, my lord, a application was made on favor of the against this mutation, my lord, for cancellation of the mutation. That was made on, my lord, in the year of 2023, my lord. Thereafter, this is the dead mutation case, my lord. This is the dead mutation case.
This is the?
Dead mutation.
Yes.
Person concerned was lessee who was
No,
died.
initially mutation has been effected in the name of Mohma Chattopadhyay.
Yes, he is a legal heir, original legal heir.
Acha. Then?
Then, my lord, an application was made, my lord, on 7th February 2023 for cancellation of the mutation order by the same mutation lessee, Srimati Mohma Chattopadhyay, and stated that the executive will on 4th October 2022 in favor of a third party.
So Mohma Chattopadhyay is not restricting.
No.
She is not restricting. She
Then what is your predicament?
Predicament is only they want permission fees. Despite several orders passed by this honorable court, that permission fee cannot be sought.
I don't know
So
whether
they are acting in contempt, my lord, of these orders.
order whether this application was made or not.
Sir, you can take the citation. These are all available.
No,
on internet. I'll hand over.
Just hand over.
I'll hand over the copy. All are available on it.
I just inquire whether this appeal was made or not. Copy din.
Take down.
At 7, I am appealing for the petition. Today I have been handed over the.
My lord, I filed the ABTBT in opposition, my lord, today.
Can 3 and 4 nahi? What is can 3 and can 4?
It is not my lord.
Huh?
Nothing,
Not mine, my lord.
nothing was not given to us.
We have also not.
You have not filed can 3 and can 4?
And no copy was.
তাহলে
not
এটা কেন
given.
শো করবে? What you are going to file?
File করেছে দেখুন না।
What you are going to file?
My lord, I filed.
Yeah, I
the
have
ABTBT
received
in
the affidavit in
my lord.
opposition. I would like to take an exception to that, my lord.
Oh, reply.
Yes, your lordship.
আচ্ছা লিখুন, the affidavit in opposition as filed on behalf of the respondent state is taken on record. Learned advocate appearing on behalf of the writ petitioner press for leave to file an affidavit reply. Stop. The affidavit reply is to be filed within 2 weeks hence. Stop para. Let the matter be listed. Let the matter be listed on May 20, 2025 under the heading
Lordship,
for hearing.
may I beseech your lordship for only one respect, not because your lordship is fixing the matter on 20th. Not on 20th, I have some preoccupation. So if you
Tell me which date will be convenient
the matter after the vacation.
after vacation. Very good. Then 10th June.
10 June কি জানি দেখি দে get 10 June
না 12টার সময় ওই ম্যাটারটা নেব 12 o'clock ম্যাটারটা নেব Mr. Banerjee's matter. Mr. Banerjee and Mr. Sarwar Hussain. Sarwar Jahan. Sorry.
নাম তাহলে তোমরা করো।
Huh. Let me come back after 5.
Yes.
Okay.
সবাই তো এখানে রয়েছে। Yes, madam. May I just remind your lordship, madam, once or from the madam, your lordship has already seen, my lord, in the impugned order, which is under challenge, my lord. Madam, yes. Yes. Admittedly, my lord, plot number. Now, I just want to elaborate such, my lord, submission. আমারটা মার্ক করে নিতে হবে। আমারটা তো আলাদা কোনো ওদিকে চালিয়ে যাবে। Your lordship has already seen, my lord, the plot which has been acquired, that is 786, no dispute, and the area is also no dispute. Now, I on the last occasion relied upon the preliminary decree. If your lordship kindly see once that preliminary, the earlier partition suit plaint, and I have handed over to your lordship. একটু বার করে দিন না দাদা প্লেনটা, এই এরম কপি আছে সুতো বাঁধা। দিদি yes, my lord, yesterday, my lord, along with the, my lord, copy of the judgment, my lord, preliminary degree, my lord, first page is the plaint. Your lordship has marked one portion also.
এই প্রিলিমিনারি ডিগ্রি পড়া কোথায় করলেন? প্রিলিমিনারি ডিগ্রিটা ইউ হ্যাভ নট ফাইল, আই বিলিভ।
I filed, my lord. একবার দুটো ব্রিফ বার করুন, আমি বার করে দিচ্ছি।
Oh, I'm sorry. This one, no? Yes, sorry. আমিও বলছি নেই ফাইল করো, তুমিও বলে দিচ্ছ করে। হ্যাঁ, এই দুটো এসি একটু বন্ধ করে ঠান্ডা লাগছে। Yes.
সব ডকুমেন্ট এখানে পেজ মার্ক করা আছে, যত ডকুমেন্ট আছে। But my learned senior friend has already bring one, my lord, documents.
The documents which have been filed before the authority, all these documents. And
Yes.
will appear from this.
আমাকে একটা কপি দাও। আমাকে একটা দিন। তাহলে but compromise decree, but it has been marked as page 5 to 8 না ডিগ্রিটা প্লেনটা লাগবে দাদা, পড়া যাচ্ছে না। But just see, my lord, instead of that, my lord, kindly see the plain, my lord.
ফ্যানটাকে চালালো, মহা মুশকিলের কথা।
বাইরেরটা বন্ধ করতে বলতে হবে। জজ সাহেবের মাথার উপরটা বন্ধ করতে হবে, একটা দুটো।
ফ্যান চালালে তো সব উড়ে টুড়ে যায় কাগজ। আমি দুটো এসি বন্ধ করতে বলেছি।
বন্ধ করলো কেন আবার? আরে জজ সাহেবেরটা বন্ধ করুন, আমাদেরটা কি? আমাদেরটা নেই বন্ধ।
লয়ারদের চাইলে যে ওরা চালিয়ে দিন,
আমাদের চালিয়ে দেবো। দেখো স্যার, আমারটাই বন্ধ করে রেখে দাও।
এ করলেন, মহা অশান্তি। এই ফ্যানটাকে বন্ধ করতে বলো। Yes.
Now, kindly see the plaint. Plaint, my lord, your lordship will not find in
These terms are Once upon a time used by Doordarshan.
Doordarshan. Now in the plaint, my lord, your lordship will find my title suit number 1 in Bengali, 129 number Devani 1962.
Yes.
Second page.
Huh.
Now my lord, kindly see the schedule. But I am
Mr.
taking.
Mukherjee, I intend to remind you that,
Yes.
that it is the contention of the writ petitioner that the additional district magistrate, as per the law,
Cannot
has,
act as a civil court.
has got no right to go to the nitty-gritty of the factual aspects.
Absolutely.
And which is why the legislature on their own wisdom has made a provision for
But the matter before the
referring
civil
the
court.
matter before the civil
Yes.
court.
If the my lord, there is already a decree passed by the civil court, if it is not the intention of the legislature that whatever may be the case, if there is also a decree, the additional district magistrate or the competent authority shall refer the matter before the civil court. Had it been the case, it is my submission is that had it been the case, it cannot be the intention of the legislature that when there is a preliminary decree, and what is the compensation? That there are some person who are entitled.
Kindly place.
On that score, I'm just placing. Don't take me otherwise. I'm just.
No, why should I?
But kindly see but I have told your lordship, rather I submitted before your lordship that plot number 786 has 4 plots now, 565, 567, 568 and 569.
তপশিল বর্ণিত সম্পত্তি।
তপশিল বর্ণিত সম্পত্তি 565 মালের 565,
yes,
then 567,
yes,
then 563 মালের excepting 565 and 567, others are not relevant for this plot number 786 which has been acquired.
Will you repeat your submission once?
Plot, your lordship has.
There are several plots of land in the schedule of the plaint.
Now, out of this, only 2 plots has been acquired by the Land Reforms Authority. Rather,
what are those?
That is, 565 and 567. Your lordship will find
565 and 566. The first one and the second
one. Absolutely.
Very good. Then,
now, others, your lordship need not be looked into.
Understand.
Now, what happened? Now, ultimately, this suit, your lordship will find, but kindly see the judgment. But your lordship will find the 3rd October 1966, this suit has been decreed. May I read, it is a next page.
I'm searching for the date.
Date, your lordship will find after the schedule, then your lordship will find
উক্ত মোকদ্দমায় বাদী এবং পক্ষে নিবেদিত বর্তমান মোকদ্দমা আমাদের মধ্যে আপোষ পক্ষে
মীমাংসা
শর্তে রফা নিষ্পত্তি হইয়া গেল।
Yes.
শর্তসমূহ।
Yes. Now kindly see the judgment 3rd October 1966. The plaintiff and the defendant have a
yes, 3rd October 1966.
Kindly turn to next page. The plaintiff and the defendant numbers 1, 2, 3 and 5 have filed solenama and they prayed for a decree in its terms. Peruse the solenama. Terms of the solenama are legal. Let them be recorded. There is no reason why a decree shall not be passed in terms of the solenama against all the defendants. It may be mentioned that the plaintiff has examined himself. There is no reason, therefore, why an ex parte decree shall not be passed against the non-joining defendant in terms of the solenama as prayed for. Ordered that the suit is hereby decreed on compromise against defendant number 1, 2, 3 and 5 in terms of the solenama and ex parte against the rest also in the same terms, be declared that the plaintiff has 1/8 share. Therefore, my share has been declared. Now,
it was a suit for partition.
Suit for partition. Your lordship will find from the first page of the plaint. Rather, if your lordship see the prayer, নিম্নের এক নম্বর মানে ইন্টারনাল
বাদীর একের
8 অংশ চিহ্নিত সুলভ
সুলভ
বিভাগ বন্টন মধ্যে বাদীর উক্ত অংশে শান্তিপ্রিয় দখলের ডিক্রি দিতে আবশ্যক। It's for partition. Yes.
Very good.
Now therefore my
So
respect
plaintiff's share has been declared how much?
plaintiff, your lordship will find that the plaintiff has 1/8 share in the ordering,
Plaintiff has 1/8 share.
that the defendant number 1 has 1/8 share, that the defendant number 2 has 1/8 share.
Amongst the parties to the suit, who are the your clients?
Not only my clients, my lord, different clients, my lord. I am not only the one of the party in the suit, but the parties who are the owners in respect of the property, particular plot.
Mr. Mukherjee, if I correctly understood,
My lord,
if I'm wrong, please correct me. I'm absolutely free to learn. What I'm on, according to you, since by virtue of the Solenama, a compromise preliminary degree has been passed, indicating the shares of the parties, the ADM, while passing the order under challenge, has practically relied upon this preliminary degree and quantified the amount of compensation. I believe it
quantified has not been made. Only, my lord, shares who are entitled. Quantification has not been
I'm
done.
sorry, let me see once.
Yes. Order dated 27 November 24.
But get compensation for, so he has determined who will entitled to get the compensation.
Absolutely. How much has not been determined? Kindly visualize.
Yes.
My learned friend is harping, my lord.
Now tell me how, just make the relationship.
Now what happened, my lord? Kindly see, my lord. But may I just complete this one? Or, yes. Now, my lord, against this preliminary decree, but if some parties are aggrieved that this preliminary degree has not been passed properly, or if some person says, I have a share, I have not been given the, my share has not been declared, remedy lies by filing application. I need not say to your lordship, my lord, there must be a miscase, or rather, the preliminary degree has to be challenged. Now, my lord, assuming this is a decree passed by the civil court has not been challenged, even if I assume this is a wrong decree, unless this is challenged before the higher forum, this is binding upon the parties. But on that score, I will rely on judgment, my lord, the recent judgment of the Honorable Apex Court. But kindly give me 1 minute, my lord. But 2016, volume 9 Supreme Court cases, page 44.
2016, volume 9, SCC 44.
But page 44, yes. Now, my lord, I will rely paragraph 54 and 55 that if a decree or order has been passed wrongly without jurisdiction, unless that is challenge is binding upon the parties. I will hand over the photocopy to your lordship's perusal, my lord. Now, my lord, next I will say that in the writ petition, your lordship will find nowhere it has been stated that, my lord, that the how his title has been derived. Kindly see once the writ petition. File Mr. Banerjee argued before your lordship, but WPA 3419. Rather, if your lordship see the cause title, he claims to be the one of the petitioner is claims to be the son of Mehmud Khan. Mohammad Khan. Oh, Mehmud আছে দেখ একটুখানি আমি যদি ভুল না বলি তোর কস্ট টাইটেলটা but this cost from the cost title your lordship will find Muhammad Alam Khan son of Mehmud তো নাকি রে বইটা কোথায় যদি ভুল দেখি চ্যালেঞ্জ না করলে অ্যালিয়াসটা বোধহয় ভুলে গেছি, আমি দিয়ে দিচ্ছি, ঠিক আছে। না মানে দিস, ও হয়তো কস্ট টাইটেলে বলেন, আমি চশমাটা পাওয়ার বেড়েছে একটু দেখে বলছি, আসবো আমি কস্ট টাইটেলটা দেখে বলছি তো। না মানে দিস পার্টিকুলার মেহমুদ খান, this Mehmood Khan or rather Mohammad Khan, he has already transferred his property in favor of his wife Badrunnesa Bibi in 1973. If his predecessor, his father rather, transferred the property in favor of Badrunnesa, and Badrunnesa in her turn transferred the property in favor of other person who is private respondent before a lordship. If I put this question to myself, can he maintain this writ petition? Because it is not dispute that the title derived or share derived from the Muhammad Khan. No dispute. If Muhammad Khan disposes his right title interest in favor of of his wife, and in turn his wife,
Mr. Mukherjee, this writ court will decide the title.
Yes, that's my lord. I have bring judgment. Your lordship, my lord. A person is coming before your lordship. Suppose today, if for the argument sake, if I say,
Mr. Mukherjee, subject matter of the writ petition is the order which, according to the writ petitioner,
is
the appropriate authority
civil court
the appropriate authority cannot
decide the same. Rather, he has to
cannot make an apportionment with regard to the amount or portion of the same with regard to the award.
I'm telling.
So why should I go before the title?
Need not. Then the appropriate authority.
The only concern before this writ court is that whether the appropriate authority has exercised its power within the periphery of the National Highways Act or not.
Absolutely. If before the appropriate authority, but kindly visualize the position, there is two parts. One,
I'm not hearing any first appeal or second appeal, Mr. Mukherjee.
I know, madam. I'm not arguing on that. I'm not saying I am covered by your lordship's court judgment. I will come, my lord. If your lordship kindly hear me,
yes, sir.
Now, my lord, I am not on that. His statement is that the award has been declared, and my lord, when there is a dispute or conflict regarding the apportionment, then it has to be relegated to the civil court. What the additional district magistrate done? This is the decree of the civil court. Relying on this decree, he just said they are entitled. Apportionment has not been made. Kindly distinguish the matter. Distinguish the fact. Entitlement has been declared. Relying the judgment of a competent civil court. In respect of a property, in respect of a plot, if I put this question to myself, how many decree, how many suit is, maybe there are thousands of suits. Now, this honorable court has held that a subsequent purchaser or a person who, after vesting the property or who, after recording the property as a vested land, acquired land, has filed a petition, he has no right. I will show that judgment. But before that, kindly visualize this situation. What is the wrong on the part of the additional district magistrate? The competent authority. Competent authority only consider the civil court judgment where it has been specifically stated, where it has been specifically declared the share. Now, if a portion has been acquired, only question comes who are entitled for the or what portion the person is entitled.
Who are entitled to the award and to what extent?
Portion has not been declared. Kindly calling for a moment.
In terms of the claims of Adalat Mahato and 6 others at serial number 27 to 33, this is to state that their predecessor and interest that is Kalipada Mahato and purchased such and such area over plot number such and such from such and such by registered deed number such and such in the year 2005.
Your lordship is reading from
cannot be considered at this stage as Badrunnesa Bibi sold her property to other property prior to one. Therefore, it stands that the Mojid Khan and Asma Begum Khan got the 50% of plot number 786 and Chandan Borai got 0.50 acres of land.
Yes.
And plot number 786. Total acquired plot is 0.919. Therefore, Mojid Khan and Asma Khatun will get compensation for 0419 acres of acquired plot. Number Sachin and Chandan Boral will get
How much not
compensation
declared?
so apportionment has been done.
Kindly see. But apportionment means who are entitled. How much has not been declared?
I understand, sir.
Now, my lord, what happened? But if your lordship considered the, my lord, order dated 27 November, kindly read with me, my lord. If your lordship has the time, my lord, kindly permit me to read. But 27 November, my lord, I have paid. I have your lordship got it. I am trying to convince your lordship in my own way, but kindly tell me. But it is not the intention of the legislature that if a decree, my share has been declared by a competent civil court, the competent authority is not bound to refer the matter before the civil court. But had it been the case, my lord, there is no preliminary decree, there is no declaration of share. Now there are conflict person who are claiming the right over the property. Yes, competent authority is bound to refer the matter. When there is a decree, when there is a decree passed by a competent civil court is on their foot, on their head, what is the wrong if I put this question to myself on the part of the competent authority? Kindly read this, my lord, order number 24. May I read for your lordship? Your lordship. I have perused all the material documents produced before me. On perusal of the case records and from the submission of the parties, the brief fact of the case summarized below. Kindly mark this. The subject matter of properties were purchased in the year 1935 by registered deed number such and such by one Nasrat Ali Khan, which I have stated before your lordship. Said Nasrat Ali Khan died leaving behind two sons, Muhammad Khan, Abed Ali, and two daughters, Jamal Banu and Jahan Banu, as is only legal here. Later on, Muhammad Khan, by deed number 4289 in the year 1951, sold his entire share in the said property in favor of Shahidan Bibi and Nashiban Bibi. Abed Ali Khan transferred his share to his wife Akbari Bibi by registration deed number 8619 in 1960, which I have stated before a lot long ago. Nashiban Bibi filed a suit in the year 1962, being TS 129 of 62. This is the partition suit.
What is the case number?
My lord, 129 of 1962. Kindly compare with the preliminary decree, my lord, or the plaint which I have handed over to your lordship. Okay.
Yes. Title suit number 129 of 1962.
Then the suit was disposed of in 1966 on compromise with a preliminary decree. Kindly mark this portion. In the order, it was mentioned that if the defendant number 2 pays a sum of rupees 750 to the plaintiff and the defendant number 1 within the stipulated period, then the share of those parties will devolve upon the defendant number 2, and the plaintiff and the defendant number will be debarred from laying any claim over the partible and the defendant number 1 partible estate. Accordingly, the sum of 1500 was paid to the plaintiff and defendant number 1. Therefore, defendant number 2, that is
just a minute. Defendant number 2 pays a sum of to the plaintiff, and the defendant number when this tribunal late, then the shares of those parties will devolve of the defendant number 2. The plaintiff and defendant number 1 chole galo to defend, and the plaintiff will be debarred from laying any claim. So the defendant number 2 will become the absolute owner. Yes. Then
thereafter, the properties of Nasrat Ali Khan devolve upon his two sons, namely Abed Ali Khan and Muhammad Khan, and two daughters, Jamal Banu and Jahan Banu. No dispute up to this.
No, therefore, defendant number 2, there is Muhammad Khan regain the property which is sold to the defendant number 1. That is the earlier paragraph. Therefore, the properties of Nasrat Ali Khan. Nasrat Ali Khan.
Who is the original owner?
Yes. Nasrat Ali Khan devolve upon two sons, namely Abed Ali and Muhammad Khan,
and two daughters, Jamal Banu and Jahan Bibi.
That's right.
No dispute. Then said Jamal Banu and Jahan Banu Bibi and their husband died issueless. Therefore, the property of Nasrat Ali Khan devolved upon his two sons, Abed Ali Khan and Muhammad Khan.
Nasrat Ali Khan.
বোনেদের সাথে
Yes, yes, I understand. Nasrat Ali Khan has two brothers, Mohammad Khan and Abed Ali Khan. Since Jamal and Jahan died useless, their shares come to their brothers. So they become 50-50.
Absolutely. No dispute.
Yes.
Said Jamal Banu and Jahan Banu, no, sorry, my lord. Abed Ali Khan, then my lord, Abed Ali Khan transferred his share to his wife, Akbari Bibi, by registered deed of 1960. Therefore, Abed Ali 50% my lord, your lordship has seen, and Mohammad Khan. এদের ক্ষেত্রে এত প্রবলেম না, ছেলে মেয়ে হয়ে যায়। আবেদ আলী and Mohammad Khan, then my lord, Abed Ali, his 50% share he's transferred to his wife Akbari.
Yes.
Then Abed Ali Khan and his wife Akbari Bibi died, leaving behind one son Majid Khan, one daughter Ashma Begum Khan.
Abed Ali and Akbari died, leaving behind one Majid and
daughter
Begum
Ashma.
Khan. Therefore, half share of Abed Ali devolved upon Mujid and Asma Khatun. Just a minute. Give me a second.
Yes, ma'am.
Yes.
Then my lord, kindly see. Now, therefore, my lord, half share of Abed Ali Khan devolved upon Majid Khan and Asma Begum Khan.
So they became 25-25.
Therefore, regarding the half share of Majid Ali Khan and Asma Begum, no problem. Petitioner also not claiming through this particular Asma Begum and Majid Ali Khan.
Yes.
Now, in terms of the claim of the Anadi Mahato and Srimati Mahato, this is to state that the predecessor of Anadi Mahato and Srimati Mahato got the plot number 786 with an area 0.25 acres and 0.26 acres from Muhammad Khan by deed number 9161 in the year 1985. But kindly mark the year 85.
But Muhammad Khan sold this share in the 1951 to Saida Bibi and Nasida Bibi initially.
Later on, my lord, subsequently, my lord, in 73, your lordship has already found 73.
Muhammad Khan by deed number in the 85.
Madam, may I just assist your lordship? Now, my lord, your lordship has seen, my lord, that Abed Ali Khan half share, Muhammad Khan half share. What Abed Ali and after the death of Abed Ali and his wife, his share, total share come to his son and daughter
Mujid and Asma.
Close chapter. Then the other part, Muhammad Khan, this Muhammad Khan, who has 50% share, he 1973 transferred his entire share to his wife Badrun Nesha Bibi. But that fact I have not stated. Now I'm.
No. According to your submission, Muhammad Khan executed a deed of conveyance in the year 1951 in favor of Saida Bibi and Nasida Bibi.
May I just
that you have stated?
May I just once see, my lord, once your lordship is saying, my
Muhammad Khan, who is the son of
but that chapter closed. That was in 1951.
That I am saying.
That chapter closed because, my lord, Saidan and out of Saidan Nasiban, one of them has filed a partition suit. In partition suit, it was agreed that if when Muhammad Khan sold the property to Shahidan and Nashiban, if Muhammad Khan give 750 to Shahidan and 750 to Nasiban, then property will be again came back to Muhammad Khan. That is the preliminary degree compromise. Therefore, kindly ignore that chapter after the preliminary degree.
After preliminary degree, what happened?
After preliminary degree, the entire portion has come to these two parts. But kindly see once again read after the preliminary degree, property ultimately came to Nasrat Ali Khan. But kindly see again Nasrat Ali Khan, 2 sons, 2 daughters. After see
Nasrat Ali. Nasrat Ali abar ki re?
But originally property belongs to Nasrat Ali.
No, after preliminary, what happened? Preliminary degree, what happened?
After preliminary degree, again property came.
Muhammad Khan regained the properties which is sold to the plaintiff and the defendant number 1.
Yes.
Oh, so it reverts back to him.
Absolutely. Then again, after,
I understand.
Again after preliminary degree,
after then Muhammad Khan, what happened?
Then Muhammad Khan, then again property came to Muhammad Khan. Muhammad Khan in 1973 executed deed of gift, rather executed deed of gift in favor of his wife Badrunnisa Bibi. 1973.
Where from will get that?
Kindly see last paragraph. Now the term of the claim of Anadi Mahato line starts with that.
Khan, now in terms of the Ato got the plot. Muhammad Khan Ato in the year 1985, but Muhammad Khan in the year 73 transferred his share to Badrunnisa. Acha.
Wife.
Badrunnisa.
If
by deed of gift.
Deed of sale. 500.
Deed of gift or sale?
Sale.
Deed of conveyance.
Deed of conveyance. Therefore, once in 1970.
In the year 1973.
Yes. Therefore, if in the year 1973, Muhammad Khan bequeathed all his property in favor of his wife, he can't sell in 1981. 1981, yes.
So, according to you, Muhammad Khan's alleged transfer to the predecessor of Onadi and Srimati Mahato in the year
1985.
No, in terms of the this is not to state the predecessor of Onadi and got the plot in 1985.
Therefore, court
so according to you, in the event this deed of conveyance is looked into
1973,
keeping side by side the deed of conveyance of 1973. At that time, the Muhammad Khan has no power to execute a deed of conveyance.
Absolutely.
Because he was divested of his property by executing a deed of conveyance in favor of Badrunnisa.
Absolutely.
Very good.
Therefore, had it been the case, it is not the case of the petitioner before your lordship that Onadi Mahato and Srimati Mahato filed a suit.
For setting aside that.
Absolutely.
Yes.
Now kindly turn. Later on, Badrunnisa Bibi in several occasions sold the subject property to many others. Therefore, the claim of legal heirs of Muhammad Khan also is rejected.
Therefore,
the claim of legal heirs of Muhammad Khan is rejected because after getting the property, Badrunnisa transferred the entire property to different persons.
Yes.
Then on one Faisal Khan, therefore, kindly mark one portion that this Onadi and Srimati Mahato, who purchased the property in the year 1981 from alleged Muhammad Khan, they never filed a suit that we have purchased the property from Muhammad Khan, therefore declaration that I am the owner of the property. This is nowhere, no document has been filed before the competent authority. Then next, kindly see. And the claim of Mr. Banerjee's client is from Muhammad Khan. Muhammad Khan. Now, the Badrun Nasa, if transfer the property in favor of other person, the legal heirs has no right.
Mr. Mukherjee, let us, I'm sorry to give you, ask you to take a pause. That I understand your contention that when Muhammad Khan executed a deed of conveyance in favor of his wife, Badrunnesa, in the year 1973, he cannot transfer self-same property in the
81.
year 1985 to the predecessor in interest of the Anadi and Srimati Mahato. Am I correct?
Absolutely.
It is your contention that in the event the Anadi or Srimati or their predecessors intends to avoid their earlier deed of conveyance dated in the year as executed in the year 1973, they ought to have filed a suit for cancellation or declaration for avoiding their to make their title perfect.
Absolutely.
The additional district magistrate has taken this point.
No document has been produced, therefore additional district magistrate has been gone. The competent authority has.
I'm asking only this question here, whether the additional district judge, additional district magistrate is within his competence to come to a finding. That I'm asking.
No, there is no, but if I say
for a limited purpose, that I intend to.
But if a person, suppose then in other cases, kindly visualize in other way. Suppose I am harping
Have
for.
you followed the question?
Yes, absolutely.
Being a court, I can understand. Being a person of legal fraternity, you can understand. My limited question is that within the periphery of that subsection, can an additional district judge take this point or not?
Additional district magistrate. Now the question is that if we consider particular one section which is 3H4, then no one will get the compensation. Someone will come and say
that is why a provision has been made for determining the apportionment or share something like by a civil court.
Civil court. Then
this is the contention of Mr. Banerjee.
If I say,
Mr. Mukherjee, don't think that I've already framed my mind. I'm asking. I consciously I'm asking you I'm putting this question since this is constantly harping in my mind whether the additional district magistrate within the periphery of this subsection can come to a finding like a civil court. That I'm asking.
May I reply, my lord? But
I know I'm troubling you.
No, it's my duty, madam. Now, when there is already a civil court decree, now, if your lordship says that the competent authority has to relegate the matter to civil court.
No, sir. Probably you have not understood your question.
No, your lordship is.
For the sake of argument, for the sake of argument, let me accept that I have, to that extent that the preliminary degree is concerned, it will go back to Muhammad Khan. Thereafter, he has transferred to the share to Badrunnesa. Up to this, I am all right. But when the question arises with regard to the title deed of conveyance of 1985 and 1973, whether the additional district magistrate can come to
absolutely, because
in absence of any document.
Exactly, in absence of any document. If there is any document that a competent civil court has nullified the transfer by the Muhammad Khan in favor of his wife, then it should be. But if the person who is now before your lordship's court, any person came from Anadi Mahato, Srimati Mahato.
The additional district magistrate, 1973 deed of conveyance has been produced.
Absolutely.
Before the additional district magistrate, 1985 deed of conveyance of this produced.
May I just check up that document?
Whether the additional district magistrate is within his competence to come to a finding on which document he will rely and on which document he will not rely.
But if
sir, don't jump. No. Look, this is a question to Mr. Mukherjee. I'm not. Sir, I don't require your assistance right now. Please take your seat. Sir, I will not hear you.
Preliminary degree wrongly given.
Don't answer to Mr. Don't answer to my question. I will pass the order.
Now, from the order sheet, I don't find. I have the present order sheet also. I don't find anything that any observation has been made about that the preliminary degree is void. or preliminary degree is not right.
Have I asked this question?
Now, my lord, 1981 did, I don't know, my lord, whether that document has been produced before the competent authority or not. Because, my lord, your lordship is maybe in the opinion, maybe formed the opinion that how the competent authority, like a additional district magistrate, will say that 81 deed is valid or 70 deed is valid. Your lordship may put this question to myself because it is after preliminary degree. It is after preliminary degree. Now, had it been the case, number one person, Anandi Mahato, Srimati Mahato, that Mr. Banerjee can argue that appeared or their legal heirs appeared and submitted that look here that I have purchased the property, therefore I am entitled for the share. And my lord, I have challenged that decree, and I am that decree, that subsequent deed or previous deed has been cancelled. Any suit is pending. If I put this question, now, my lord, if your lordship is considered only, my lord, 3H4, then, my lord, no person will get the compensation. Suppose today I have so, in respect of one plot, I have so many enemy. Then, my lord, one person can, I have a share. Very well. Sent to the civil court, and for 20 years again, it will be in the deep sleep. Because kindly see, since 1962, my lord, we are moving for this particular plot. Now we are in 2025. Now, my lord, the legislature has, my lord, created some statute, some provision, absolutely. But that does not mean that, my lord, when there is a competent, my lord, share has been declared. Had it been share has been declared, and again, my lord, the matter has to be relegated to the civil court that who is entitled. But according to the, my lord, this preliminary degree, who are entitled has been specifically mentioned. To what extent? Now, if the document has not been filed before Mr. Banerjee's client, before the competent authority, can competent authority go beyond the document which has not been filed? If I put this question to myself. Now, my lord, similarly, my lord, other portion has also been discussed. Now, ultimately, what held? Now, ultimately held that my lord, the competent authority. Therefore, the total acquired area a plot is 786 is 0. Such and such. Therefore, Majid Khan and Asma Begum will get compensation of such and such area, and Chandan Maral will get compensation of such and such area. Now, my lord, Majid Khan, Asma Begum, there is no dispute, my lord. Therefore, if we consider, my lord, the order of the competent authority, but your lordship has to consider that the Majid Khan and Asma Begum, there is no dispute, at least from the petitioner side. At least from the petitioner side, they are claiming title from, my lord, other second one.
Where from the Majid Khan and Asma Begum comes?
Majid Khan and Asma Begum, my lord, your lordship has seen that, my lord, there are two person ultimately became the owner of the property.
Mohammed and Abed.
Abed Ali and Mohammed Khan. And Abed Ali, my lord, this Abed Ali, my lord,
Akbari Bibi.
Akbari Bibi, both died.
Oh, Akbari too from Majid and Asma.
Yes, Majid and Asma. Therefore, according to Mr. Baner, this petitioner has no right about this, my lord, from their share. Why they were not entitled the compensation, my lord, for this filing this writ petition? Because if I consider the case of
Majid Khan, Asma Khan got 50%, such and such. Very good. These are
therefore Mr. Banerjee is claiming from whom? Let him clarify his case. He is claiming from whom?
Asman Khan will get compensation. Will get compensation for Atul.
Let him clarify from who is claiming. For this decade,
Mohammed Khan.
I'm claiming
you are Mohammed Khan. You are claiming from Mohammed Khan, no?
Very well, Mohammed Khan's wife.
I am claiming from both nations.
Kindly mark this. Kindly, my lord, take note of this.
My lord,
both
my learned friend completing submission, my lord, I will show that the competent authority has interpreted the preliminary decree in its own way.
Let him clarify from whom he is claiming. He cannot claim from both. Both do not very well. Kindly delegate the matter. I am not for them.
I claim title from Bodrunesh.
Well, I mean,
you are the predecessor. Your predecessor is Mohammad Khan.
Yes.
Very well.
Mohammad Khan to Bodrunesha, and my lord, Mohammad Khan has, by dint of the preliminary decree, he has got the share of Shahidan and Nasiran. Further, my lord, they have the other two sisters have filed their written statement in the partition suit, and they have said that by oral heba they have transferred their share to Mohammad Khan also. So Mohammad Khan.
Well, let him so.
So Mohammad Khan gets 75% share.
Where from? Where from? I'll let him so.
My lord, this was my contention that was placed before the competent authority. That's why, my lord, I say whether
My contention, let him show the document before the computer.
How do you get the 75%?
75%, 50% from as I have 750 each.
On account of the death of your two sisters.
No. Mohammad Khan gets as Mohammad Khan, my lord, in terms of the compromise decree, he pays rupees 750 each to the plaintiff and the defendant number 1 and the defendant number 2 there. Therefore, their share at Mohammad Khan gets 1. Thereafter, my lord, in the same suit, the other two sisters, because Nasarat, my lord, it takes the family tree. Nasarat has 2 other daughters, Jamal and Jahan.
Nasrat.
Yes. These Jamal and Jahan, by oral hevanama, they transfer their share to me.
Nowhere it has been stated.
My lord, it's part of my pleadings. Kindly takes my paragraph 3 of my paragraph 7 of my writ petition. In the written statement, they have said that. So, my lord, I get 75%, 50 plus 25, 75. The other legal heir, that is Abed Ali Khan, from whom Mr.
So, according to you, what is the basis of the finding of the additional district magistrate that after the death of Jamal and Jahan, their shares devolve upon equally upon Mohammad Khan and Abed Ali?
Could not do so because in view of the oral hevanama, and that was placed in the written statement also.
Well, let them show the written statement, my lord.
Very well, I can place the written statement.
And hear the other respondent, then Mr. Banerjee.
And my lord, not only that, my lord would kindly take into consideration how my learned friend is claiming title by dint of an affidavit. Chandan Moral gets his title by an affidavit.
I am not for Chandan Moral.
You please take your seat, Mr. Banerjee.
But she's a rival questions, my lord, it has to be decided.
Very good.
I am not for Chandan Moral. I am only for, my lord, this particular, my lord, the 2 person, my lord, Majid Khan and Asma Begum. For Majid Khan and Asma Begum, according to Mr. Banerjee, in the written statement, they have stated about the oral heba. I am not causing for a moment, let them produce the written statement.
Okay.
That has not been filed before the competent authority. But kindly see the document. Let Mr. Banerjee produce the original document, which has been not stated before the competent authority. Now, first time they are saying, let them, Mr. Banerjee, produce that written statement.
Just stated. My lord would kindly take my petition as stated that the representation I have categorically stated.
A document is required. Written statement is required. He may say so many things. Then it must be recorded in the preliminary decree. It must be recorded. Declaring the share. It must be recorded. He is saying in a petition suit he has filed that written statement.
In a judicial review, I shall go into this.
Then if that be so, then my lord, the
judicial review, can I do this?
Need not, if your lordship don't.
If I hear out a preliminary, first appeal, I can understand.
Then, my lord, if your lordship rely his statement, which has not been produced by the competent state authority, that can your lordship rely on that? If I put this question to myself, I am appearing for 2 person, Majid Khan, Asma Begum. His only intention to set aside the entire award because it is his specific statement he is claiming from Badrunesha. Very well. He is not claiming anything from my predecessor. 25, at least 25 release. He is saying, my lord, he is owner of 75. At least 25 I am the owner. How long I will wait for a compensation, my lord? Let for the timing 25 be released. No dispute by them. If I accept his
Very good. Any other point?
Yes. Now your lordship is putting the question, my lord, whether your lordship can go into. But what he is arguing, this is also, my lord, about the title, about the property, whether in read court can entertain this or not. Whether read court can entertain the disputed title or can decide anything. But your lordship is relying, my lord, 11, my lord, this particular provision, but 3.4, but 3H4, that the relegation of the, my lord, before the civil court. But what he is pleading, he today as first time for the timing is saying that the written statement they have stated oral heva. In Muhammad Allah, oral heva, very good thing. By oral, my lord, I'm diye dilam. Now the thing is that has to be proved. Whether your lordship sitting in 226 can gone into all this question. What the competent authority has done, competent authority, what are the document has been filed, relying that document pass the order. The document which has not been filed by before the competent authority, can your lordship in 226 see that document or gone into that document which has not been placed before the competent authority, if I put this question?
Very good. Any other point?
Now, to that extent, I will just relate two documents, two judgment, my lord. One is, my lord, old judgment 1970 volume 2 Supreme Court cases 149.
1970
volume 2 Supreme Court cases, page 149. When there is a dispute about title and everything, read court should stop. Read court should not interfere about all those things. Disputed question of fact. But what he is saying, that I have document, I have written statement, oral heva. Can your lordship in 226 can go into the? But kindly consider this.
I don't want to enter.
No, your lordship.
I don't want to enter. What I intend to do, whether I intend to examine whether it is within the periphery of the additional district has to go into the title or not.
But if I say, had it
is as simple as that, man.
Had it been he gone into the title, the document which has been filed, he relying on, had the submission, passed the order.
There are some disputed questions.
But they
are vis-a-vis the.
But let him show that it is a specific case that he has not
intends to show before the civil court there.
Absolutely. His only intention just to set aside this and go back and wait for 20 years. My son, my grandson, everyone will come again. Another thing, kindly see. Number, his specific case in the writ petition, he was not given an opportunity of hearing. Specific case, then what? How he can say?
That point he has not.
No, he is saying that I have produced.
He has raised about the jurisdiction.
No, he said I have produced, I have stated everything. How can he? He just made the submission before your lordship. Oral heva, everything has been stated, everything has been. Now it is his own case, contradictory pleading. Now, but consider this aspect regarding my portion. At least my 25% I'm for the timing I'm entitled.
Very good. Yes. Give me those reported decisions. 2016 and 1970.
And my 2006 volume 5 Supreme Court cases 255. 2006 volume 5 Supreme Court cases 255.
What are the relevant paragraphs?
My relevant paragraph, my 8 and 9. A 3-page judgment, my
And 1970 cases, what are the relevant paragraphs?
1.5 page judgment. Kindly go through.
You are appearing on behalf of
10 and 11.
Respondent number 10, 11.
Before.
Respondent numbers 10 and 11.
Game খেলা হয়ে গেল।
You are Mr.
দীনবন্ধু চৌধুরী।
হ্যাঁ।
Yes.
Can I leave my?
Yes, yes, Mr. লিখে দিয়েছো? এইটাও লিখে দাও তো, রেসপন্ড নাম্বার 2 বলে, নাহলে মনে থাকবে না। এইটাও লিখে দাও। Yes, Mr. Chaudhary.
But before going into the merits of the impugned order, I shall try to satisfy your lordship on the point of jurisdiction of the authority.
You are supporting their petition or not?
No. I am opposing.
Achha.
The authority has power to come to this conclusion that
and
whether
Mr. Banerjee is appearing? State.
On the question of entitlement, the authority has jurisdiction and power to decide whether this person who has come with a claim is entitled to it or not.
Legislature divided these two parts in two sections. Why? There is a provisions for apportionment. If there is a dispute, it will go to the civil court. Now the definition of apportionment, my lord, will find from the dictionary or in the law I have found or searched in the Transfer of Property Act. That is section 36 of the Transfer of Property Act. Can you see, my lord will get certain idea what is apportionment. Now, Banerjee. In the absence of a contract or local usage to the contrary, all rents, annuities, pensions, dividends, and others periodical payments in the nature of income shall, upon the transfer of the interest of the person entitled to receive such payment, be deemed as between the transferor and transferee to acquire due from day to day and to be apportionable accordingly. So there will be question of entitlement. If it appears that he is entitled, there will be apportionment. Now, can we come to the Act, National Highway Act? Section 3H. The legislature divided two things separately, subsection 3 and subsection 4. Why? Not to push the litigants or common people in civil litigation to suffer for years after years. But you can see the subsection 3, where several persons claims to be interested in the amount deposited in subsection 1, it has been deposited. The competent authorities shall determine the persons who, in its opinion, are entitled to receive the amount payable to each of them. So authority has power to determine who is entitled. Now, thereafter apportionment. Question of apportionment will come after deciding the issue relating to entitlement. Now, in this case, what the authority has done. But I will show other points which has not been taken. The writ petition is liable to be dismissed with exemplary cost. I will come to that point later on.
Give me a second.
After deciding the question of entitlement, the question of apportionment will come. That is subsection 4. Now, what the authority has done? Authority, in going to determine that who is entitled, he has power to determine. He has simply explained the documents which are either in the court or in the register office. If they want to dispute that determination is perverse, then they have to show that the documents which have been relied is not in force, it is illegal, or it has been stayed. Otherwise, they have nothing to say. He has not said anything. He has only explained the documents. Now, kindly come to the writ petition. Paragraph 9.
Yes.
Paragraph 9. But before that, I want to submit one thing. Now it has become trend to make a chance case. If something get after settlement, we will get something, start a case. Now paragraph 9. the petitioners categorically state and assert that they claim title from their predecessor in interest, Muhammad Khan, and others legal heirs who, though have not joined as petitioners, are party to this instant writ petition, are on the same boat of the writ petitioner. Their case is this: they have been claiming title from the Muhammad Khan. Now, Mr. Mukherjee has explained Muhammad Khan was the owner of the 50% of the property. There is no dispute. I need not to show all these documents, partition suit, share, etc. Not necessary. He is starting from Muhammad Khan, so back I need not to go. Now kindly come to page 12, paragraph 18. Para 18.
Yes.
Petitioner states that the respondent number 4, while passing the order impugned, has erroneously held that the Muhammad Khan, the predecessor in interest of the petitioner, and Abed Ali Khan have 50% share in the concerned plot number 786. I am pausing for a moment. And the dispute in this case is only for the plot number 786 and nothing. No. The respondent number 4, which is bound by the degree of civil court, is supporting my case, has not decided the share of the parties in terms of the preliminary degree and the subsequent transfer made by the deceased Muhammad Khan. So it is in his knowledge that Muhammad Khan transferred his all share, entire share, to his wife Badrun Nisa. Now, Badrun Nisa has transferred his entire share in respect of this plot 786 to different persons. So their entitlement ends. What should be the remedy? They have to go before the civil court. They have to go before the civil court, which they have done. They have suppressed this fact. They took a chance case before the civil court, failed. They have come in the writ court, again chance case. Both the writ petitioner filed this suit.
You have filed this?
Now,
no, you have filed this?
Huh? No, not in this. It will not be there. So they have already filed a suit. Kindly come to paragraph 15 and 16 in page 14.
Page
14 of the plaint. It is a certified copy of the plaint.
Page 14, huh?
Paragraph 15 and 16.
Just a minute.
They have explained everything.
Just a minute.
They have explained everything about this accusation proceedings.
Para 15.
15 and 16.
Finally, please, sir.
That a portion of the suit property acquired for the purpose of extension of NH 32, that is the subject matter of the writ petition and others. A proceeding has also been commenced for the purpose of assessment of award, being LA case number 21. Such and such, this is the case. The authorities concerned have erroneously held that the legal heirs of Saidan Bibi, Nasiman Bibi, such and such entitled to compensation. They have challenged it. The plaintiff asserts that a substantial share has been devolved upon the legal heirs of Muhammad Khan, the predecessor interest of the plaintiffs. It is their case in their suit. It is submitted that in the aforesaid proceeding, being LA case number such and such, the competent authority and or additional district magistrate and competent authority of land acquisition highway, by holding that the legal heirs of Saidan Bibi, Nasiman Bibi, Jaman Banu, such and such are entitled to the compensation and have gone into intricate civil dispute as to whether Nasiman Bibi and Saidan Bibi had accepted sum of rupees 750 such and such and such. Now kindly see the order
So,
sheet.
according to you, practically challenging that hour, they have filed a civil suit and availed the alternative remedy.
Kindly see that they have failed to obtain any order. They moved injunction.
Achha.
Now on merit relating to the findings of the authority, the writ petitioners has no share. Now if they have filed a suit, they have failed to obtain any order of injunction, that suit is still pending. And in the next case, there is a different facts and different case. I will be praying to dispose of the first writ petition.
No. So upon this document, what would be your submission? That they have availed the alternative remedy?
They have already availed.
Common law forum.
Yes.
For the self-same relief.
Practically, right, entitlement. Now I'm submitting another thing. But
what is their prayer? For declaration of Atto such and such with the observation of no manner right title of Atto for apportionment. So according to you, the prayer which has been made in the instant plaint, the certified copy of which has a direct bearing with the order which is challenged under in the instant.
Indirectly, it is practically
Has
they
it
are
been-
entitlement.
Has it been disclosed in the instant writ petition regarding the filing of the suit?
No. This was possibly it was not informed to Mr. Banerjee. I know Mr. Banerjee. Need not to
So
go all
would
those facts.
it be your contention that in the event this court allows the writ petition and direct the additional district magistrate to relegate the matter to the principal court of civil jurisdiction, there will be a chance of conflicting judgment.
They cannot entitle for this order. Already now they are to show the order of.
Try to understand.
Yes, ma'am.
They are aggrieved with the finding of the additional district magistrate. Since according to them,
not finding of the present, not finding of the present.
Sir, try
present
to
order.
understand my question, then answer. So far, please answer to my question. Would it be your case that since the instant writ petition has been filed, being aggrieved with the finding of the additional district magistrate with regard to the apportionment of the award, since they have filed the title suit, and in the event this court passes a direction while allowing the instant writ petition, relegating the matter to a principal court of civil justice, the district judge of the relevant district, according to you, that will have a direct bearing upon the suit.
There will be, because can you see, first thing, there is no question of apportionment.
Very good. Come to the
There
next
is no
one.
order.
I understand. Come. What is
There
the
is no
next
order.
one?
Entitlement. For entitlement, they have filed a suit. Failed to obtain any order of injunction. Not order, forget about the order, because order has been passed subsequently. The order impugned. Mr. Mukherjee has already
They
submitted.
continue after 2 p.m.
Yes,
Oh, 2
I
PM
can
matter,
finish
no?
by 1 minute. Then I'll see.
You have completed
I will complete now.
within a minute. Very good.
Oh, a few minutes I will complete. Okay, okay, very well. Can it 2 p.m. Okay, mal.
What do you want?
Work very good. Oh, sorry, mal.
No, that's all right.
No, can't.
If you want, I can continue up to 2 o'clock.
No,
That's
no. Before rise, kindly
2
take
PM.
it 2 p.m.
Today.
তোমারটা পরে হবে
Ask we have heard you.
তোমার রিটটা পরে হবে
One thing I will show you that they are misrepresenting one fact. The field kindly
Oh, they are within their right to make misrepresentation. Don't worry.
that I have to clarify for Lord.
No, it will continue at 2 PM.
next রিট পিটিশন
কল্যাণ আমি না তাহলে ওই I'll take about this.
before rising
My junior would be there.
Yes, yes.
For days accommodation, but I will make my submission on next day if it's possible.
Yeah, make your submission, no?
Reply,
Reply will be confined only to the point of law. I have to finish it. This bill hearing I don't like.
Representing a fact. They're distorting the fact.
before
Mr. Banerjee is supporting the case of the
An order has been passed by the authority. So that I am supposed to not support
Support
the
that
finding
order.
of the
before rising just one submissions and we have heard or learned this thing in our early practice in 1985-86 that if you want to blow purchase a new pipe you cannot be allowed to blow in the other's pipe. Concept is this: the defendant cannot claim any relief against the defendant. Similarly, respondent cannot. So they have no right to say in this matter.
I shall consider. Let us come back at 2 PM.
WPA क्या नंबर है?
सिर्फ आइटम नंबर 1 फॉर द पेटिशनर की रेस्पोंडेंट। पेटिशनर तो ये है ना, जयपाल है ना? पेटिशनर जयपाल। हाँ तो उसका भी आएगा लगता है, क्वालिफिकेशन ऑन कर था वो उसका भी ना काफी।
Mr. Banerjee not to participate in any judicial proceeding from 2 p.m. So, but I understand, Madam, that has not been circulated till now. But
no, when it has been communicated through you.
Yes, no, this has been communicated in our group, my lord, and since no committee member, so my lord.
Samir, sound नहीं आता।
Since this has been, my lord, circulated through our.
Very good. Mr. Jayapal, then.
Nuclear matter, because my adverse side is there. I may not claim for a main disposal, but
take up tomorrow at 10:30 a.m.
Eviction order, my lord, tomorrow at any moment they would throw me. I can understand. I'm bound by. I bow down to the resolutions of this court. But at the same time, Lordship, I have some urgency. I've come from Port Blair.
No, if you want to do, I'm.
My adverse side is also there, my lord.
Yes,
Just I would not take much time. Just simply for the purpose.
Since my learned friends have come all along from the
That has been taken subject to correction if all the sites are there.
No. That is not the resolution. If you don't know the resolution, please don't say this. Please, not to participate in judicial proceeding from 2 p.m.
So for a sport matter.
No, please, you can carry. You can carry.
I'm ready.
Yes. Who is for the? You are for the petitioner.
Madam, I am appearing for the private respondent. I am raising maintainability of the writ application, my lord.
Malad, I am for the.
I am for the official respondents, my lord. 1, 2, and 3, my lord.
But I am also for the official respondent.
Other matters we should go.
Yes. If there is a resolution, you can.
But we are challenging the maintainability first. So
Give me
let
a
the
second.
maintainability heard at first.
I have challenged.
My lord, writ petition
Give
is
me a
not
second.
at all maintainable, my lord. Maintainability, I may be allowed to address first, my
May
lord.
kindly come to page 93, my lord. The second appeal which has been
Madam,
dismissed
wait.
my lord.
Wait for some time. Where is your prayer in the writ petition? Yes.
Here is at page 20, para 2.
Where is the order impugned?
Finally comes to order of the page 101. 101.
Give me a second.
I've not been heard before passing the order. I don't know if it's
इसको तो स्पीकर खराब है, इधर में आ जाइए।
Yes, Mr. Jayapal.
So for us, my property is concerned, Lord, It's 34/1/15. The orders which the Tahsildar have relied pertains to the land of the private respondent. I am concerned with my property, which is in survey number 34/1/15. I'll show my papers, sale deed, record entry showing my name.
But the order has been passed for eviction in respect of 34/1/14 or 14?
No, it's a 14 only.
1/4. But in the penultimate paragraph, it has been typed as a 40. It's a typographical error. So, so it is in respect of 34/1/14. 1/4. So how you are agreed?
I am deciding over 1/5.
Huh?
Based on this order, they are trying to evict me from my property. Both the landed properties are continuous plot.
How it can be?
But this is how the Tahsildar have passed the order.
No, where is that order? Where is the order for eviction of 34/1/15?
Not there. But I have based on this order, they would evict me from my property. It is a claim of the private respondent. I have occupied their land in 34/1/14. So the Tahsildar passed this order. And the orders of the High Court, orders of the Civil Court pertains to 34/1/15. I filed a suit.
How do you justify your contention?
I am deciding over my property, not
to stay. Decide there.
I require a protection. So far as my property is concerned, I should not be dispossessed. I'll show my deed. So far as this order is concerned, I have no problem. But so far as 15 is concerned, I should not be thrown. I'll show my property papers.
But Malad, how can an apprehension order be passed?
Yes. So far as my property, because
apprehension, how can it be?
Challenging an order.
Appreciate one thing. I'll show my sale deed, my lord. Now kindly turns to page 25.
No, sir. Kindly come to prayer first. What is your prayer?
My prayer is to set aside the order of the Tahsildar.
Then
page 20.
So it means that is this order in respect of 34/1/14.
Yes. My pleading may kindly be seen, Lordship. I have said specifically, not kindly appreciate. It happens so. I am a continuous plot holder. The private respondent claims that I have encroached this 14, based on which this order of Tahsildar has been passed. Tahsildar says you are in 14. So I would throw you out from the suit land, the subject land. But I am residing in my properties. I am concerned with my property. So far as
how a read code will decide that?
This has to be gone into in the finally. This matter needs to be gone into. Firstly, my lord, the Tahsildar passed the impugned order without giving a notice. It's a civil, not most. Eviction order has a civil consequences. I brought the judgment of Supreme Court. No notice even has been served to my client.
And that suit was filed, suit was dismissed up to High Court.
Sir, what I'm on, you have, what is your prayer in the read? It is a read for quashing of the order, which is under challenge. That is at page number 101. That pertains to 34/1/14.
My lord.
You say that you decided 34/1/15.
Yes, my lord.
So why this court will pass an order restricting him to not to give effect to this order?
That order can be given effect to, but so far as prayer portion, interim prayer may kindly be seen at page 21, not page 21. Interim order staying the operation and oblique of further operation of the impugned eviction order dated 22nd April 2025, while RC number so and so passed by the Tahsildar by restraining respondents authorities from disturbing the possession of the writ petitioner or the subject land, that land in survey number 34/15, including prohibiting the respondent authority from dismantling the standing residential house of the writ petitioner or the subject land.
What is your pleading, Swami? What is your pleading, Swami?
Plain, my lord.
Pleading.
Yes, my lord, I'll show you. But kindly turns to paragraph, page 11, paragraph 12, my lord. The grounds I've taken. I may be allowed to place this page 11. 12A, my lord. There is no reason assigned by the respondent number 3 in passing the impugned eviction order. Requirement to record the reason emanates from the doctrine of fairness in decision-making process. It would be evident from the impugned eviction order that there is no reasoning assigned by the respondent number 3 in passing the impugned order while directing writ petitioner's eviction from land bearing survey number 34/1/14 by ignoring the relevant material, being the reports and possession certificate, wherefrom it is crystal clear that writ petitioner is possessing land bearing survey number 34/1/15, over which he has raised building and residing along with his family members. Moreover, the previous proceedings against the wife of the writ petitioner was in connection with land bearing survey number 34/1/14, from where she was allegedly removed from the intervention of the Honorable Court. Respondent number 3, while passing the impugned order in exercise of power under section 161 of Andaman and Nicobar Island Land Revenue and Land Reform Regulation 1966, failed to give any reasoning to arrive to a conclusion that the writ petitioner in fact possessing the land bearing survey number 34/1/1, which warrants eviction and not over land bearing survey number 34/1/1, which is duly recorded in his name
which by itself vitiates.
So you are claiming that you are deciding in 14, not in 15.
I'm in 15 only, Your Lordship. My point, Lord, kindly see, I said that
Failed to give any reasoning to arrive to the conclusion that the writ petitioner in fact possessing the land in survey number 14, which warrant eviction and not over land in survey number 15.
Tahsildar said that I'm on 14. Tahsildar said in the impugn that I'm in 14. So there has to be reasoning. There has to be an inquiry. Not kindly see the regulation 161(1), under which the order has been passed. There has to be an inquiry to be done. Regulation 161.
My kindly see the agreement. His agreement specifically says that he is residing in 15.
Lord, kindly have a look to regulation 161(1).
My lord, only one. I may be permitted to submit only one thing.
I will give you a chance. I will give you a chance.
Kindly tell to regulation 161.
Maintainability is to be.
Mr. Prashant, he will get you a chance. I assure you.
Fully obliged, my lord.
Kindly come to regulation 161. On page 33, Lord would see, this is a power vested with the Tahsildar to evict. Lord, kindly see, after commencement of this regulation, any tenant is dispossessed of any land held by him otherwise than by process of law. He may within 2 years from the date of such dispossession may apply to the Tahsildar for his reinstatement in such land. 2 is very vital. On receipt of the application under subsection 1, the Tahsildar shall, after making an inquiry into respective claims of the parties, pass order on application, and when he orders restoration of possession to tenant, put him in possession of the land. But kindly now see the impugned order. No inquiry was held by the Tahsildar to come to a conclusion that I would be removed. This is a mandate of law, Lord. Lord, kindly see the impugned order once again. It's under regulation 161. Basic law decision-making process is he has to not kindly see the impugned order once. Suit and all, I will come to that. Page 101. There is no inquiry conducted by the Tahsildar saying that the possession of the writ petitioner is over the land of the private respondent, because the eviction has been directed from 14, which is recorded in the name of private respondent. I'm the adjacent plot holder, my lord. And I'm in 15, I do admit, my lord. But my apprehension is, without any inquiry being done based on this sketchy order, I would be thrown from my landed property by dismantling my residential house tomorrow. It's a mandate of law. Now, inquiry is required to be done. He could have held inquiry, he could have issued a notice, or I've taken a specific ground in my writ petition. No notice was given before passing the impugned order.
So what is the agreement?
What?
By under which document you came into possession of 14?
Yes, I'm
15.
grateful. I'm grateful. I'm grateful. I'll show that out. I'm grateful. Just 1 second.
Page 27.
Page 27. Just 1 second.
25, starting from 25, sale date.
Just 1 second. 25 is the sale deed. Malad kindly comes to sale deed, which my client.
What is the name of your client?
Shakti Bay. Shakti Bay.
Yes.
Malad kindly see page 37, the schedule. Schedule. It's 34/1/15.
Yes.
My lord could see next page 44. I have obtained permission from the defense to raise my building, which was accorded at page 44. And now I'll show the possession certificate issued by the same officer, Tahsildar. I'll show that.
Mr. Jaipal, I cannot understand that when a Tahsildar passes an order for eviction in respect of plot number 14, and when you are, according to you, you are in settled lawful possession of 15, survey number 15, then how you are going to agree by that order?
No, they would throw me because that, no, kindly see page 1. No, that's the apprehension. That's, no, it's well founded. Not kindly appreciate. Both the
What is the basis of the apprehension? Kindly tell me, sir.
Page 103 may kindly be seen. I'll show 103, the possession certificate.
Yeah,
and the map I'll show, my lord.
If you have encroached, 14 days will be thrown out. No issue.
I'm not encroached.
It is not your case.
No, it's not my case, my lord. Page kindly see, my lord. 103. So I'm in possession.
All are in respect of 15.
My lord. But what has happened, my lordship? At one point of time, there was a threat of disposition. I filed a suit for permanent injunction. That was dismissed.
First appeal lost. Second appeal it was not admitted. These three orders were considered by the Tahsildar in the order impugn to hold that I am in 15. I am in 14. I'm sorry. That's the reason, Lordship. Kindly see the impugner once again. I'll show this suit. What is all about suit? Suit was with regard to the permanent injunction for my protection of my property. I lost the suit saying the court said that you could not place any evidence to show that there was a threat of dispossession. There was an affirmation by the first appellate court and this honorable court in second appeal.
Where is the plaintiff other suit number 18 of 2021?
Yes, it's a part of the
One
application.
page I will show, my lord. Page 90, page 93 may be seen. Picture will be clear.
I'll come to that. I'll take the pen. Well, kindly see the judgment of the trial court in the suit, page 56. Now, page 56 is the trial court of the trial court in my suit.
Is under occupation of Matthew Joseph.
Yes, my lord.
No, my lord, kindly, this is not the fact. Let me place my case, my lord. Let me place my case.
You don't know where you are, which land you are occupying.
Tahsildar says, Lordship, it's over the Lordship, eviction has been done in respect of 14.
No, there is a finding of the division bench that in respect of 34 survey number 15, Matthew Joseph is in occupation.
Yes, this is my land, my lord.
Orders all interlocutory nature, my lord. Kindly appreciate.
What are you saying? Second appeal.
Yes, my lord.
Second appeal was dismissed. It is an interlocutory order.
Pertains to a suit in connection with my property, my lord. In connection with my property.
So you are not in 15 then.
No, I'm in 15 only, my lord. Possession certificate which I have shown just now.
But that has not been accepted by the High Court, division bench of the High Court.
That was not taken care of by the Tahsildar while passing the order. He simply said to pass the order considering the High Court's order. I could have been given a chance, my lord. I could have placed these documents.
But you have not come before the court with a clean hand.
Yes, my lord. That is the.
You are saying that you are in 15. High Court division bench observation by dismissing SAT is that you are not in 15. 15 is in occupation with Matthew Joseph. So on the if you say that if you are 15 and that contention is also not right.
Lord, kindly have a look to the order.
No, Mr. Yes, Mr. Prasad.
My lord, first order passed by this honorable court, page 47. I will not take much time, my lord, only 2 minutes. Page 47. My property, the petitioner encroached. This is the first order passed by the honorable High Court. On 19th April 2017, my lord, kindly see how many years I am litigating. This was affirmed by page 50, directing the Tahsildar to throw him out.
Give me a second.
My lord. Page 47 is the first order.
In page number 47 to 49,
my lord,
the plot number has been mentioned.
Revenue case number was mentioned, same property.
14 or 15?
Number was mentioned. Yes, same property.
14 or 15, Mr. Prashant?
My lord, actually, he encroached 14, my lord, but actually 15 is in possession of Matthew Joseph.
That I have seen. Then
I approached the Tahsildar. Tahsildar passed an eviction order long back, 2015-16. That was not complied. I approached the Honorable High Court. High Court said that comply the order. That is the page 46, 47.
Then
this order was challenged by me before the Honorable Division Bench. Kindly come to page 50.
Yes.
50, my lord, operative portion may be seen. 52.
Yes.
The Honorable Division Bench directed for execution of that order. Passed in this RC case number 728. Removing the writ petitioner herein.
Where from will get that?
Thereafter, my lord, he filed the suit.
Where from will get that?
Page 52.
It is there, my lord, page 52.
52,
we have gone through the orders so passed by the Honorable Single Judge. We do not find any illegality or infirmity in the order so passed by the Honorable Single Judge.
In RC case number?
RC case number, my lord, 720.
728/TPB/2014.
Give me a second. Give me a second.
My lord, absolute suppression of material facts by the writ petitioner.
My papers, how could I suppress it? I have placed it on record.
But there's a clever drafting, man.
My lord, Tahsildar's order is at page 53. In that survey number is mentioned.
Just a minute, just a minute.
My lord.
No, Mr. Prashant, so far as RC case number 728 TPB/2014,
my lord,
that order has been passed by the Tahsildar.
Yes, my lord. For execution of that order, I approach the Honorable Single Bench.
For execution of that order.
My lord.
Now you come to page number 101.
My lord. My lord, maybe I will be permitted to submit, my lord. There are sequence of events are there.
Very good.
My lord, this single bench order was challenged by me by filing appeal, my lord. That is page 50.
50, yes.
Yes.
Then
50, my lord, operative portion is page 52, last paragraph, last second paragraph.
Yes.
My appeal was allowed.
Yes.
Thereafter, page 53, my lord. Page 53, Tahsildar passed on order. In that, Lordship will find second last paragraph. And whereas the order passed by the Tahsildar Port Blair in the revenue case number TPP so and so is to be implemented by removing the unauthorized occupation of Srimati Jain, the wife of Saktivel, the petitioner's wife. That proceeding was initiated by wife. This proceeding was initiated by husband.
Yes.
Over the land bearing survey number 34 1/14. Got it, my lord?
Yes.
Tahsildar passed this removal order. My learned friend filed a suit. That is appearing at page 78. Page, my lord, 57. 57.
Yes.
57, my lord, the operative portion, page 70, second paragraph may be seen. Finally, the certified copy of survey report dated 3/12/2019 by the surveyor Jayanta Haldar, page number 4950 of Exhibit A, clearly depicts that survey number 34 1/15 belongs to the plaintiff Sri Saktivel, is under occupation of Matthew Joseph, and the land bearing survey number 34 1/14 belongs to Sarla Badia, was under occupation of the plaintiff. Ultimately suit was dismissed. Recording this finding.
Who is the plaintiff there?
Plaintiff is the petitioner, writ petitioner. Saktivel. Lordship will find page 57, the cost title.
No, the land belonging to survey number such and such, which was under occupation of the present plaintiff, that is the present writ petitioner.
Yes. And with this Matthew Joseph.
Matthew Joseph. It's under occupation of Matthew Joseph, not under occupation of the petitioner.
Please wait. This dismissal order was challenged by filing appeal.
Page 78, man.
My lord. My lord, appeal court's order at page 78. The important page is page 87. आवाज नहीं आता सुनिए Page 87 was carried in second appeal.
Give me a second.
My lord.
Yes, then
Page 87, my lord. Dismiss the appeal before the district judge was dismissed.
First appeal was dismissed.
First appeal. Thereafter, second appeal, page 93.
Page 93, my lord.
No admission, straight away dismissed, holding that the property of the writ petitioner is under occupation of Matthew Joseph. He encroached my property, my lord. Last 10 years, I am running pillar to post to get the property. He has not filed any appeal against Honorable Division Bench order before the Honorable Supreme Court. It is binding. My respectful submission is that, my
any
lord,
other point, Mr. Prasan?
respectful submission is that the writ petition is to be dismissed with exemplary cost, my lord.
Yes.
You're for the? I am for the respondent number 1, administration, and the administration. My lord, my contention is this writ itself is not maintainable, since there is an alternate remedy under section 28 of the LR and LR regulation 1966, sorry. So there is a
Regulation number?
Regulation 28, my lord.
Regulation 28.
Of Land Revenue and Land Regulations 1966, my lord. Where he can go before the STO.
Regulation 28.
28, my lord.
Statutory appeal, my lord.
Let's 28(1) clause A, my lord. If such order is passed by any revenue officer subordinate to subdivision officer, whether or not the officer passing the order is invested with the powers of the deputy commissioner subdivisional officer, if such order, so these are under the conditions where the appeal can be made. You can go before the SDO, thereafter there is a deputy commissioner, thereafter LG is there, thereafter he can come before this court. There are division benches order, when there are
If my lord says
High Court cannot entertain,
notice was issued
By
to
the
101, my lord.
Writ petition. The writ petitioner has prayed for issuance of appropriate writ of the writs against the respondent authorities, more specifically against the respondent number 3 for quashing of and obligor annulling and obligor rescinding and obligor cancelling the order dated 22/4/2025 as passed by the respondent number 3 authority, whereby and whereunder the respondent 3 authority have passed an order for vacating the unauthorized occupation of the land bearing survey number 34/1/14, bracket wrongly typed as 34/1/40, situated at Lamba Line Village under Sri Vijayapuram Tahsil, or page number 901. Survey number 34/1/40, wrongly typed as situated at Lamba Line Village under Sri Vijayapuram Tahsil on or before April 30/2025. Stop para. In course of his submission, Mr. Jayapal, learned senior advocate appearing on behalf of the writ petitioner, at the very outset submits before this court that as a matter of fact, the present writ petitioner is in lawful occupation of survey number 34/1/14 15, my lord, in the Selsom village, pursuant to deed of sale as executed on 18/5/2015, a copy of which has been annexed at page number 25 to 43 of the instant writ petition. It is further submitted that from page number 44 of the instant writ petition, it would reveal further that the name of the writ petitioner was duly mutated in respect of the said plot number name of the writ petitioner was duly mutated in respect of the said plot number, plot bearing survey number 34/1/15. Stop. It is further submitted by Mr. Jayapal that since the writ petitioner's plot number 34/1/15 is contiguous to plot number plot bearing survey number 34/1/14, the writ petitioner reasonably apprehends that by dint of the order under challenge dated 22/4/2025, the writ petitioner may be evicted without due course of law by the respondent number 3 authority, for which the instant writ petition has been filed with a prayer for grant of with a prayer for passing interim order in terms of prayer number Roman small 4 of the instant writ petition. Stop para. Per contra, Mr. Prashant, learned advocate, appearing on behalf of the private respondents, however, contends that the writ petitioner has not approached before this court in clean hands. It is submitted by Mr. Prashant that the writ petitioner is actually in forceful and wrongful possession of plot bearing survey number 34/1/14, and that the same would be evident from the copy of the judgment as passed in from the copy of the judgment dated 27/2/2024 as passed in West number 18 of 2021, ব্যাকেটে লিখে রাখো শ্রী শক্তি ভেল ভার্সেস সরলা বৈদ্যা, পেজ নাম্বার 57 বলেছি না আমি, এখানে নামটা পেয়ে যাবে। As disposed of by the learned Civil Judge Junior Division First Court, Port Blair, ANN Islands. It is submitted by Mr. Prashant that from the copy of the said judgment as passed in West number 18 of 2021, it would reveal that the writ petitioner's contention that
Page 70, my lord.
Give me a second, sir. The writ petitioner's contention as plaintiff that he is in occupation of the plot bearing survey number 34 by 1 by 14 has not been considered in the said suit favorably, which is why the said suit was dismissed for default and I'm sorry, dismissed for now. I'm sorry, dismissed, was dismissed. And thank you, Mr. Prashant. And challenging the said order, the writ petitioner, being the plaintiff appellant, though filed title appeal number 5 of 2024 before the learned district judge, ANN Island, but the said appeal was also dismissed. Stop para. At this juncture, Mr. Prashant, learned advocate appearing on behalf of the private respondent, also draws attention of this court to page number 93 of the instant writ petition, being a copy of the order dated 18/3/2025 as passed by a division bench of this court in SAT 2 of 2025. It is submitted by Mr. Prashant that while dismissing the said second appeal, a division bench of this honorable court came to a definite finding that the plot bearing survey number 34 by 1 by 15 is under occupation of one Matthew Joseph. And it is continuation, it is the submitted by Mr. Prashant that the contention of the writ petitioner that he is in occupation of the plot bearing survey number 34 by 1 by 15 has got no leg to stand upon. Stop. It is further submitted by Mr. Prashant that it is so that there cannot be any justification to interfere with the order dated 22/4/2025, in as much as the said order is very speaking, and in such order reference has been given in respect of disposal of the say aforementioned title suit, title appeal, as well as the second appeal. Stop para. Sorry, your good name?
Divesh Dwivedi.
Mr. Such and such, learned advocate appearing on behalf of the ANN administration, while supporting the contention of Mr. Prashant, draws attention of this court to Regulation 28 of the ANN Island Land Revenue and Land Reforms Regulation 1966. Stop. It is submitted on behalf of the ANN administration that under the said Regulation 28, the order passed by the Tahsildar is an appealable order. Stop. It is just submitted by him that since the writ petitioner has an efficacious alternative remedy, the instant writ petition is not at all maintainable. Stop para. This court has meticulously gone through the entire materials as placed before this court. This court has also perused the entire materials as placed before this court. Oh, I'm sorry. This court has meticulously gone through the entire materials as placed before this court. Stop. This court has given due consideration over the submissions of the learned advocates for the contending parties. Stop. Coming to the factual aspects of this court, this court finds that while passing the order dated 22/4/2025, the respondent number 3 has passed an order for removal and vacating the unauthorized occupation of the land bearing survey number 34/1/14 situated at Lamba Line village under Sri Vijayapuram Tahsil. Stop. No materials could be placed before this court on behalf of the writ petitioner that the writ petitioner is actually in occupation of the said plot bearing survey number 34/1/14. Stop. Though it has been contended by Mr. Jayapal, learned senior advocate appearing on behalf of the writ petitioner, that since the writ petitioner is in occupation of a contiguous plot bearing survey number 34/1/15, and there is every apprehension of his client that he may be evicted by dint of the order under challenge, this court finds no force in such submission, in as much as in the order dated 22/4/2025, this court finds no whisper that the respondent number 3 has passed any order for eviction of an unlawful occupant from the plot bearing survey number 34/1/15. Stop. No other materials could be placed before this court by the writ petitioner that how his interest is going to be prejudiced if the order dated 22/4/2025 is going to be prejudiced. Stop para. As rightly pointed out by Mr. Prashant, an advocate appearing on behalf of the private respondent, that there are sufficient materials before this court that the writ petitioner is actually not in occupation of the plot bearing survey number 34/1/15, and such finding has been arrived at after conclusion of a trial by the jurisdictional civil judge, which has been confirmed in the title appeal as well as in the second appeal, and further, while disposing the said second appeal, a division bench of this court has come to a definite finding that in respect of plot bearing survey number 34/1/15, one Jacob Matthew, no, Mr. Where is that order?
93, my lord, page 93.
One Matthew Joseph is in occupation of the said plot bearing survey number 34/1/15. Stop. In view of the discussion made here in above, this court finds that the writ petitioner has miserably failed to make out a case to get any favorable order in absence of any material to substantiate that he is either in occupation of the plot bearing survey number 34/1/14 or in 34/1/15. Stop para. On careful consideration of the order dated 22/4/2025, it does not appear to this court that the said order is in any way cryptic. Stop. On the contrary, it appears to this court that the respondent number 3 has passed a elaborate reasoned order. Stop. This court thus finds no perversity in the order under challenge. Stop. Paradigm. This court thus finds that the instant writ petition is devoid of any merit, and the same is thus dismissed. Stop. Para. There shall be, however, no order as to cost. এই বইটা এটা লিখে নাও।
After few minutes, I'll take back.
Yes, sir.
After few minutes.
Yes. ওটা লিখে নাও বাবা।
I'm extremely obliged.
So, what can we? So, I am handicapped today.
Take up the matter.
When we not take us a mixed minor, at that point of time, the communication was not with us. That has on WhatsApp minor. Octopus that was
not to pass any other in presence of the other.
No, if you participate, I don't have any objection. If you,
না না করে
why should I?
করে না কোনো প্রবলেম সবাই তো আছে
এটা লইয়ার তো নেই
এটা কি আমাদের কাছে কমিউনিকেট হয়েছে?
এটা লইয়ার তো নেই
In absence, condone the absence of the law, maybe any of the members are not present to participate in the judicial proceeding, and kindly not pass any adverse order. All parties are not present.
It is not there.
only state
Mr. Banerjee was there. কি আর করা যাবে এই তো আর
কোথায় গেল দেখো অয়নকে
চলো
সকালবেলাটা মোটা নয় দুটো
2 PM.
হ্যাঁ
2 PM.
বলো 12টার সময় বলো 12টার সময় হ্যাঁ বলো In the last order, my name has not been recorded. Fees has been paid or not? State আছে আজও আচ্ছা তো তুমি বলবো
You people tied my hands. What can be done? Anyway, call the other matters. No, I know him for a considerable length of time because
বইটা আছে থাক কোনটা ও আমি এটা ফুটে ছেড়ে দিয়ে চলে যাচ্ছি
Five, 96, 97, 98, 99, 100, 101, 100 plus, 104, 5, 106, 107, 109, 110, 111, 40, 140, 150, 160, 170, 180, 90, 121, 123, 124, 5, 126, 128, 129, 130, 131, 132, 134, 135, 136, 137.
My lord, in 142, Mr. Supriyo Chattopadhyay and Ms. Iti Dotto is appearing for the state.
Three, 135, 135, 151.